The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. Morning, Mr. Camden. Ready?
Your Honors, and may it please the Court, good morning.
Morning.
Mr. Bell's, the government's motion to dismiss the appeal in the case first should be denied, and Mr. Bell's sentence at the statutory maximum of 20 years should be reversed. I can address those in either order, but to begin with the motion to dismiss the government filed. There are really four arguments I think we're making in this case. First, by way of background, Mr. Bell was originally sentenced to this term of 300 months. He filed a 2255 based on Davis. The government did not oppose that, and there was a plenary resentencing, and this is an appeal from that resentencing just in 2023. And the question really is whether the terms of the plea agreement, which purported to waive appeal, apply at this stage where the resentencing was a remedy for a 2255 that was granted. And the first argument is that the terms of this, properly and strictly construed against the government, both as drafter and in order to protect the constitutional and statutory rights of Mr. Bell, do not cover a sentencing appeal at this stage. The second is that even if the terms did cover it, were unambiguous and clearly covered it, that it is not enforceable due to a lack of consideration in the plea agreement. Next, I think, and I'm going a little bit out of order from what the briefs are, but I think lack of consideration comes before frustration of purpose. So even if the court determines that there was some sort of purpose or some consideration in this plea agreement, the principle of frustration of purpose is one that the government has frequently invoked in order to be able to be relieved.
Are you seeking to put aside the entire plea agreement?
No, Your Honor. Our position is we're within the plea agreement still. There hasn't been any violation of any of the promises that were made within the plea agreement.
But an argument that the plea agreement lacks consideration or that its purpose would be frustrated seem to undermine the entire agreement, wouldn't it?
If we were asking to exercise some right that we had waived in the plea agreement, then we'd need rescission to be able to do that, I think. But so if the court determines that this plea waiver covers this situation and applies to waivers of appeal of resentencings, then yes, I think it would be rescission of the plea agreement because it's just not, it's unenforceable due to any lack of consideration. And I can delve a little more into the consideration issues. So and I put out in a chart in the briefing, but this plea agreement, Mr. Bell, of course, gave up a lot of rights. He gave up the right to go to trial, the right to have a jury, even the right under the Fifth Amendment to have a grand jury pass and have an indictment. He pled guilty to an information. He waived appeal, at very least, of the direct appeal of the sentence that was to be imposed on that plea. And in exchange, the government's promises were to file or to request the third point for acceptance of responsibility, which they had no discretion to deny because Mr. Bell had pled before a trial date was even set and had not litigated any issues, and freely admitted his guilt in the statement of facts. And aside from which, the Sentencing Commission in Section 3E 1.1 has expressly forbidden the government, and this court, even before that, in 2011, had forbidden the government from extracting an appellate waiver in exchange for recommending the third point for acceptance of responsibility. So that can't be consideration. There was an immunity provision, and that's the only other substantive promise the government made in the plea agreement that's filed, that promises immunity for any crimes or conduct specifically described in the statement of facts, which ordinarily would be some sort of consideration, but there is a gaping hole, an exception, that says except for crimes of violence under 18 U.S.C. 16, which, and the only thing the statement of facts describes is a crime of violence. Hobbs Act robberies, the conspiracy no longer is, but he already pled to those. and the 924C counts.
What about felon in possession?
So it does not, so it says conduct specifically described. So it describes that Mr. Bell provided a revolver, I think, to the co-defendant.
So possessed it.
It says provided. I'm not sure exactly what the circumstances of the provision were.
It would have
I
to
mean,
either be actual
and
or constructive if he provided it, wouldn't it?
it's possible. It's possible to provide a gun to somebody simply by telling
It's
them where
likely,
it is.
I would think. Go ahead.
And I apologize. And I think the facts are what they are, and they're certainly described in the plea agreement in more, or not the plea agreement, the PSR in more detail. But here the immunity provision only applies to conduct that is described in the statement of facts. And it describes the provision of a revolver to the co-defendant. Number one. Number two, it does not state or allege that the firearm had traveled in interstate commerce. It did not even allege, although we're not disputing, that Mr. Bell had a prior felony conviction or under a hafe that he knew that he was had a felony conviction that would have disqualified him.
And all of this is going to the lack of consideration? That's your argument?
Yes, Your Honor.
Go ahead.
So I don't see that the immunity agreement or that the immunity provision would have precluded the government from filing a 922G. It certainly doesn't, it didn't at the time, and doesn't preclude them from charging the additional 924C, which the government says was consideration, but there's no promise not to charge that, or a brandishing count, which would have been a 7-year as opposed to a 5-year 924C mandatory minimum. So there's the last, or the second one is that even if the court says there was some sort of consideration in the background here, the frustration of purpose doctrine is something that the government frequently invokes when it doesn't achieve the benefit, and that it was expecting. And in the courts, and I've cited a few cases, at least in the district court, that where the government's invoked that and been allowed to be relieved of its obligations under the plea agreement. And the frustrated purpose must have been so completely the basis for the contract that, as both parties understand, without it, the transaction would make little sense. So in this case, back in 2012, the exposure would have been to stack 924Cs, as the government notes. Our first position, again, obviously, is they didn't promise not to charge that in the first place. There was an immunity provision that carved out a huge exception that would have let them charge that anyway. But the intervening event cannot be fairly regarded as within the risks the frustrated party assumed under the contract, and the non-occurrence of the event must have been a basic assumption on which the contract was made. And this is the cases we cite in the briefs, Bunner and the second restatement of contracts. In this case, the change in the law is really what happened between 924C stacking was abolished and made retroactive by Congress. Davis came in and made the conspiracy not to, or precluded the conspiracy as a valid predicate for 924C.
But after the intervening change in the law, there's still 2 counts that he remains convicted of, right? So the basis for the plea is he would be convicted of those in exchange for these promises from the government.
Yes, sir.
Right.
Well, to the extent there are promises, yes, there are, yes. That would be the consideration.
And those
I mean,
that's still good, right? He's still guilty of those 2 counts, and the government's keeping its promises.
Absolutely, Your Honor. He certainly kept up his end. He's been convicted. We're not attacking or challenging the conspiracy counts.
Mm-hmm.
It was a 20-year statutory maximum on each count. The government, in fact, asked for part of that to be consecutive, so he's exposed to up to 40 years in this case. And we're not challenging or attempting to undermine or withdraw the plea for those counts that he pled to. That's correct. I'm happy to address any more on that, but the specific performance issue is sort of the last argument. And
Just to make sure I'm clear, just take 10 seconds. What exactly is the frustration?
the frustration is, so when the subject of the contract, sort of the purpose for which the party entered into it, is gone. And in this case, again,
Otherwise, you're saying that now based on where we are now, he had no need to have a plea agreement at all? What's the frustration?
That's exactly the argument. So this is an
That's
alternative.
what you're arguing, right?
Yeah, this is an alternative
At this
argument.
point, because how the world is now rectified, as you say in your way, that if we started ab initio, he would just say, oh, I don't need a plea agreement. Is that right?
I think that's more or less correct, Your Honor.
Well, what about what Judge Rushing just asked about those remaining findings of guilt that he still remains to be sentenced on? Isn't that still something that's important to him?
Yes, Your Honor, but we're not challenging that. He's not trying to withdraw his plea. He's been convicted.
He just wants to not withdraw it, but to excise that part that says the waiver part.
Correct. If the court construes it to apply here and finds that there was some sort of consideration, then frustration would be the next
I'm sorry,
step.
go ahead. I just want to understand because that's one part of your case. Go
Absolutely.
ahead.
Please interrupt, Your Honor. I'd rather clarify than just talk to
Go
you.
ahead. Go ahead, counsel.
So specific performance is really, and this is sort of a broader picture question about what to do when somebody appeals if they are in violation of the promise not to appeal in a plea agreement. And ordinarily, in many cases, even in published cases, this court has just dismissed the appeal up front. In this case, though, we have an explicit list of negotiated remedies in case of a breach of the plea agreement. So the first point to make is this plea agreement purported to waive appeal of the sentence
Have we ever taken that approach to a defendant appealing when they have an appeal waiver? Don't we normally just hold them to their promise and we reject the appeal, right? Is there any authority that you can cite for a case where we've considered filing a notice of appeal a breach, and then we've consulted the remedies in a case of a breach section of the agreement?
I am not aware of a case where that has been decided, but I'm also not aware of a case where it's even been argued, Your Honor, or raised as a point.
Well, it seems often those remedies are less favorable to the defendant, right?
Often, yes, Your Honor. So it may just be the fact that a dismissal happens and then that's the end of the matter. This is kind of a special circumstance given the intervening 10 years that he spent in the Virginia Department of Corrections, the fact that he was stabbed and the government didn't oppose the 2255 here. This is, frankly, a pretty unique circumstance. But in any case, the plea agreement, one, we know that the waiver of appeal provision can't be enforced to the extent that it's written, because it purports to waive appeal on any grounds whatsoever for the length of the sentence and the manner in which the sentence was imposed. And this court has, of course, held that that can't be enforced where, for example, the district court were to consider some race or commit some sort of egregious constitutional violation. So, or there's a claim of ineffective assistance of counsel. The modern and the current plea agreements usually have that exception laid out. But this one doesn't. So we know it can't be enforced as written to the extent that it's written. So there are certain circumstances where a defendant, even with that.
But you're not arguing any of those circumstances
No.
apply here, right?
No,
This
we're
is
not.
just a straightforward waiving. He waived the right to appeal any sentence on any ground, and now he's trying to appeal his sentence, right?
The resentence, yes.
Right.
As on a remedy.
Which is a sentence. It's the sentence he will be serving.
It is the sentence he will be serving. Oh, yes, absolutely, Your Honor. So, I kind of skipped over the initial argument, which is just on the language of the plea agreement and the terms and the context. And I'm happy to focus on that at this point. The language of the plea agreement, the word sentence in this appellate waiver provision appears several times. There is the advice that the 3172, or I believe, provides the right to appeal the sentence imposed. And then it says the defendant waives appeal of any sentence, and the government quotes that language, but it's the part that follows. It says any sentence within the statutory maximum, in parentheses, or the manner in which it was imposed. So any in that, first of all, the sentence imposed seems to contemplate the sentence that's going to happen when I plead guilty here in this case. That's the next step of this case. Any sentence in the abstract could be ambiguous or could refer to any sentence at any time, at any stage of any future proceedings. But with the full sentence being any sentence within the statutory maximum or the manner it's imposed, that reflects directly the arguments that are typically made on appeal in a sentence, that the sentence was procedurally or substantively unreasonable, either too long or a mistake was made in the process. So it seems to, properly construed in that context, refer to a sentence of any length, not a sentence in any stage in the future. And even if this were a civil contract and there were some ambiguity here, the important background principles here are that it is construed against the government, not just as drafter, but because defendants are giving up fundamental constitutional rights. And because Mr. Bell, for example, in this case, is going to have to spend another 20 years beyond the 10 he already spent in Virginia DOC in an environment where they can't protect him. He was stabbed. In exchange for this appellate waiver. So the courts have been, this court, in fact, has been clear that it has to be completely unambiguous. It has to be obvious and clear from its meaning, and any sort of ambiguity or reasonable construction that benefits the defendant has to be given in these cases. So with that context, in addition, and I apologize, I'm out of time with 7 seconds, but it doesn't include a 2255 waiver, which so many of these other cases that the government cites does. Thank you for your time.
Thank you, counsel. Mr. Arnold?
Good morning, Your Honors, and may it please the Court. Daniel Honnold for the United States. This Court should enforce the appeal waiver and dismiss this appeal because this appeal waiver is valid and it covers the defendant's sentencing challenges from his post-2255 resentencing. I think I'll start my remarks this morning by just noting two things that are not on the table that this Court commonly sees in these types of challenges. The defendant does not dispute that his plea and his knowledge of the appeal waiver itself were knowing and voluntary at the time that he entered into them. And he doesn't dispute that if the appeal waiver indeed applies to post-2255 resentencings, that the sentencing challenges he raises in his opening brief are squarely foreclosed and covered by this appeal waiver. So turning to what my friend is actually challenging here, our position is that it's quite clear that the appeal waiver in this case does cover all manner of sentencings, resentencings, whether it be in a post-2255 proceeding, a vacatur and remand for resentencing, for example, in the Roger Singletary context, or any other number of cases in which this court has continued to enforce the appeal waiver beyond the direct original sentencing. I'll start with the language. I think that's probably the best place to start. We're not operating on a blank slate here. This court has twice, to my knowledge, construed the clause any sentence within the appeal waiver that the government and defendants typically enter into. In Thornsbury, it described that as, quote, quite broad. And in Blick, it said, quote, the language of this waiver, which is any sentence, is exceedingly broad. So to the extent that my friend argues there's ambiguity in the phrase any sentence, that's been foreclosed by this court's case law in which it has unambiguously held that this language is in fact broad. And in the language here at JA 19, the phrase any is invoked twice, first to cover any sentence and then to cover a challenge on any ground whatsoever. The use of that expansive and broad language is meant to connote an appeal waiver that's going to cover the maximum amount of ground possible. I'd also note that this court has squarely confronted this issue in the post-2255 sentencing context, in Jones, in Parker, which we cite, in Jackson, which we did not cite, but which is cited in the Boone case, 583, Federal Appendix 280, and by other courts in the Cooney case that we cite, and in the Borden case in the Second Circuit that we cite. Courts uniformly hold that these types of appeal waivers apply to the post-2255 resentencing context. The reasons for that make a lot of sense in light of Haddon, which indicates, as Judge Rushing was referring to earlier, that the post-2255 sentence is the sentence that the defendant is serving. And there's no reason logically to distinguish it from the original sentence for purposes of the coverage of the appeal waiver. I'm not seeing any questions from the court at this juncture. I'm happy to address further the defendant's counter-arguments with respect to consideration. Actually, there is something I would like to point out that has to date been unaddressed by my friend, which is the information, in addition to the charges that we forewent as part of the plea agreement, the information that we brought to the court's attention in sealed supplemental appendix pages 32 to 38, which we reference on pages 9 and 10 of our reply in support of the motion to dismiss. This is not a closed proceeding, so I'm not going to go into detail unless the court asks me to, but we've provided that information to the court as additional consideration on top of the foregone charges, including the 922G1 that Judge Rushing mentioned earlier. I'll briefly touch on frustration of purpose. Given the opportunity here today, my friend has still not been able to say what purpose of his has been frustrated. I certainly can't imagine that it's been, that it would be that perhaps one day in the future, a decade after his original sentencing, one of his charges would be vacated by an intervening Supreme Court decision and he would be resentenced to a lower sentence and would be able to appeal from that. That's too speculative of a chain of events to have been a purpose that he had when he entered into this plea agreement. And that's all that we are asking this court to foreclose by enforcing this appeal waiver. Finally, specific performance is a contract remedy that applies when a party is in breach, and it's when the aggrieved party asks the court to order the breaching party to do something specific, like a sculptor being commissioned to, make a sculpture, and the court orders that person to finish doing the work. We're not asking the defendant to do anything here, and we've not alleged that he's in breach of this contract in any way. So specific performance, the invocation of it, is simply a category error here. Those are all of the contract-based attempts to invalidate this entire plea agreement. None of them succeed, and the broad language of this appeal waiver unambiguously covers the particular procedural posture that we find ourselves in here today. And so we'd ask that the court enforce it and dismiss this appeal. Unless the court has any questions about the merits of the sentencing challenges that the defendant raises in the opening brief, which I'm prepared to address, I will yield the rest of my time.
Thank you, counsel.
Thank you.
Mr. Camden, you have some time reserved.
Your Honors, first to address the information the government referred to in the sealed appendix at 32 to 38. The document is not there. The government did not submit it. We don't have it. I don't have it. I didn't have it. Our office obviously did not represent Mr. Bell at that original proceeding in 2012. But there are things that the district court said that make clear that there was no promise from the government in that case. There was no representation that anything would be done. It was entirely within the sole discretion. And when there is a contract and the performance is in the sole and unreviewable discretion of the opposing party, that is not valid consideration, especially where there's no standard the court can apply. That was, and the government submitted and made this argument, I think, in its reply to our response to the motion to dismiss. I'm happy to submit further cases on that if the court requires further briefing on that. But in any case, the specific performance issue is, I don't think, a category error because when this court dismisses an appeal, it is essentially, obviously there's a defendant who is appealing, an appellant who wants to appeal, and the court's simply deeming them to have previously waived appeal under the terms of this plea agreement when the plea was entered and when they didn't know what sentence they'd received. They didn't know what, if any, grounds or whether the grounds of appeal would be. So that is, number one, a good reason to construe that waiver narrowly. But number two, it is a different situation than when a defendant wants.
Aren't most plea agreements entered into before the defendant knows what she is going to be sentenced to?
Yes, Your Honor.
Okay, well,
And
that's not a difference, is it?
Well,
Is it?
it is for this district simply because, so I've spent my first 7 years in the Southern District of California, and I've done a survey of all the districts, and this is obviously not in the record, but basically it comes out about a third. I think the bare majority or plurality have an appellate waiver typically at the high end of the guidelines or a negotiated amount. Minority have these appellate waivers that they extract here, which is through the statutory maximum for any reason, for any purpose. So
It
this
tells that the court is not bound by anything like that, so that's a plea that's already entered into, agreement already entered into and accepted by the court, and you still don't know what you're gonna be sentenced to, right?
That's correct, Your Honor.
Right, and that's part of the process, so I'm just, again, to me, I'm not gonna open up the can of worms you've argued, but it's just hard to find
No.
this frustration or the, it looks like contract of adhesion argument you're making either, but go ahead.
And I wouldn't challenge, I don't say it's unenforceable ever, I just do think that that is a reason to construe it narrowly and not to extend it. Basically, you look at the plea agreement here and the appellate waiver, it just doesn't talk about 2255s at all. What happens if there is one? And this is choice, it's just not contemplated. When a person enters a plea.
Do you have any authority refusing to enforce an appellate waiver like this on these facts, on a resentencing? Your government pointed to some cases enforcing these sorts of waivers. Are there any cases where courts have refused to enforce an appellate waiver on a resentencing like this?
Not that I'm aware of, and not where a defendant wasn't making an argument that, for example, an egregious constitutional or due process violation. Not that I'm aware of, number one, but on the other hand, the cases where this court only has Jones, which is unpublished, and the government cites that as some sort of authority or precedent on the premise that we have the same facts, the same language, and we have an outcome which was dismissal of the
There's
indictment.
Jackson, I believe, too. I know the government mentioned they didn't put that in their brief, but we have
Right, and
another unpublished.
I wrote down the site, Your Honor, and
Yeah.
I'll certainly look that up. But in any case, Your Honor, number one, it's unpublished, and that's enough, I think, to say it's not binding. But number two, even unpublished decisions are only entitled to the weight that their reasoning employs. And when you have fact...
Sure, but
and
there's
then-
no, I'm just curious if I missed any case with persuasive reasoning going the other way. I want to make sure that we've considered everything that's out there, and I hadn't seen anything, but I didn't know if I missed something.
And I apologize, Your Honor, I have not been able to find anything. These, I've not, honestly, the arguments I'm making here are kind of just novel. I don't know that there's case law one way or the other on, for example, the consideration issue, and they're also very fact-specific. We have this particular language in this plea agreement, and there are lots of other plea agreements with different, more expansive waivers that cover at different stages or have different exceptions, so...
Let me ask you about, because he did say Haddon. How does that, I mean, it seems as if that case is, you know, the appeal is the entire criminal case, a part of the criminal case. I'm just trying to understand your argument and how you reconcile that with Haddon.
If I could, I understand I'm out of time. If I
You
could
answered
the
Judge
question.
Benjamin's question.
Thank you, Your Honor. So Haddon did reflect, well, Haddon also
Because
discussed...
that was a 2255.
It was,
Yeah.
and it was a resentencing, I believe. It was a, but it reflected, it stated that really 2255 proceedings, I believe the term it used, are hybrid proceedings. So it has some aspects of civil cases in the habeas context and also some aspects of the criminal case, because the remedy for the civil case is essentially something that happens under the criminal law and is appealed under the statute governing appeals of criminal sentences. But that does not essentially transform the plea agreement language we have, which just doesn't talk about, mention, discuss, or provide any remedies for or coverage for 2255 proceedings. It's entered in contemplation of the typical process, which is you enter a plea agreement, you plead guilty, you're sentenced, and then you go off and serve your sentence. It didn't anticipate this other thing. And so the government is asking for it to extend to cover these things. And the government's perfectly capable of writing plea agreements that do extend through 2255 proceedings. They do frequently and in many of the cases that they cite. So if there are no further questions, I'm certainly, thank you for that.
Thank you. Mr. Camden, I know you're not court appointed. I know you're part of the Federal Public Defender's Office, but thank you for the assignment court gave you, and I appreciate your
Thank you, Your Honor.
representation. And also recognize Mr. Arnold's representation of the United States. We'll come down, Greek Council, and proceed to our next case.
Good morning, Your Honor. May it please the court.
Yes.
It's difficult to lose a case at the Supreme Court on an issue that matters for what happens down below. But the district court opinion that this court is reviewing is based on Long 1, which is no longer good law. It's no longer good law because of the decision that the Supreme Court unanimously made in Ficre v. FBI. That case dictates what this court must do here. And with regards to the no-fly list pertaining claims. And the rationale in Ficre is on all fours to this case. And this is, I think, the heart of it. Just like in Ficre, the issue that put the case beyond the mootness argument that the government was making was that quote, it is enough to consider one aspect of Mr. Ficre's complaint. Quote, he contends that the government placed him on the no-fly list for constitutionally impermissible reasons, unquote. That is exactly what Sadiq Long alleges here. Sadiq Long alleges that the reason that he was placed on the no-fly list is because of his belonging to the Muslim community, because of his exercise of his Islamic beliefs, and that is the basis for it. These allegations are well pled. Look at paragraph 11 of the complaint, where we say that almost every single person on the list is Muslim. That allegation is based on a My Eyeballs review of a leaked copy of the watch list, where we determined that over 98% of all names of the watch list are Muslim. Over 99% of the names on the no-fly list are Muslim names. Even if the court just takes the name of Islam's prophet, a third of all entries on the watch list have either as the first name or the last name, the name of Islam's prophet. You could look at the allegations on JA 8486 in the equal protection count itself that details extensively how the government utilizes religious profiling, takes into account a person's Islamic religious practices in making those watch list decisions. And Ficre also explicitly rejects the arguments that the government continues to make here. One of the precedents that Ficre does set in its mootness ruling is that the passage of time during litigation is not a basis for their mootness argument. A case, this is from the Supreme Court, a case does not become moot when a defendant suspends his challenged conduct and then carries on litigating for some specified period. This is the second time this case has come before the court and the government comes in here on mootness issue. It's also the second time the government enters this court having recently developed new facts to weaponize their mootness argument. However, this is what the Supreme Court said both in its majority and concurrence in Ficre. It anticipated that these cases would go to discovery. This is what the majority said. Litigating disputes beyond the motion to dismiss stage can present evidentiary challenges for parties and courts alike. That means that this court should reverse and remand and allow this case to advance to discovery. The concurrence does emphasize that there is some possibility of a future reconsideration of a mootness holding, but it also anticipates discovery. Non-classified information or information obtained in discovery from the plaintiff is what could be used in further proceedings from to show the mootness. The consequences of Ficre's holding means that count one, the substantive due process count that is exclusively based on his placement on the no-fly list, his prior placement on the no-fly list, this court must treat that no-fly list claim as if he's on the no-fly list. That's what the application of the voluntary cessation doctrine means. It means that he can continue to press the claim even after the government has stopped its listing. With regards to the procedural due process claim, I don't know what the government submitted under seal. They haven't showed me, they haven't told me, and my client has not even received the letter, and he's a long-haul truck driver, so might not for some time. But the consequences to his TWIC and hazmat license, we've already been here too, Your Honor. 5 years ago, the government granted and then denied one of those licenses. And they granted it, and he had it for about a month, from September to October 2020, and then they took it away. And then they let it sit for 5 years. And just days before this court's hearing, then they did something with the applications, and we don't know what they did with the applications. But the hazmat license.
You would agree that those are not final at this point?
No, Your Honor. We don't know we don't know what they did with those applications, Your Honor. But
Do you not have the documents? They filed them.
No, Your Honor, we do not have the documents that they filed. My client has not received them. They've not provided them to me directly.
I mean, they're on ECF,
I think, Your Honor, they're under seal, Your Honor, I believe.
but they sent them to him, like it has his mailing address here.
Your Honor, because he's a long-haul truck driver, he has not provided them to me. I have not.
Do you want me to read it to you so you can have it?
Your Honor, I'm a little bit nervous about doing that in open court without having an idea of what it says, because it's been filed under seal.
You can respond to the motion to seal. That would help the court.
Yes, Your Honor. But let me do it as like if it's been approved, Your Honor. If it's been approved, his watch list placement had an effect on the processing of his hazmat and TWIC credential. That 5-year delay was the result of the watch list placement that the Terrorism Screening Center imposed on him almost a decade or more than a decade ago. Just like the watch list placement resulted in his revocation of the TWIC credential previously, it can again result in the revocation of these credentials if they've been granted. If they've been denied, then it's a final agency action, certainly, and we've plausibly alleged that these credentials cause him to be screened against the watch list, and denials for people that match against the watch list follow as a matter of course. And so whatever the TSA did with his TWIC and hazmat licenses, another agency will do with future permits and licenses and future interactions with the federal government. And that's the heart of the part of his challenge that does not regard voluntary cessation. He is currently on the watch list, and the government has not, at least in public filings, taken the position that he's not on the broader watch list. That broader watch list is going to impact every single interaction he has with the federal government going forward. We have that in the complaints that the TWIC and the hazmat credential were affected by his watch list placement. We also have it in the complaints that this is what they do. The TSA screens people when they apply for licenses and permits against the watch list, just as every other federal agency does. And so what is in the complaint right now is about TSA, but that's not all that's in the complaint, because the government disseminates his watch list status across the country. It's resulted in Sadiq Long's ongoing, repeated stops by the police department in the city that he lives in. And the fact that the police department has entered into a temporary case-specific stipulation does not eliminate the future possibility that either this police department or some other police department, having received from the FBI official notice on their computer as they're pulling somebody over, that the person they're pulling over is a known or suspected terrorist, we know what that police officer is going to do. They're going to approach that encounter much more severely. And that's exactly what happened to Sadiq Long. Because of the FBI notice that Oklahoma City Police Department received, he was pulled over repeatedly at gunpoint and handcuffed.
Did we talk about that sort of thing in El Hadi?
Your Honor, the issue in El Hadi was that the court basically treated it as a facial claim. The court said in claims like when you take a roundhouse swing at the watch list, the standard is higher. And I take that to mean that when you seek relief for claims, for issues that are beyond the things that happen to you, that creates a facial kind of claim. The procedural due process claim has facial elements, but everything that we're raising here happened specifically to Sadiq Long. We're not talking about police stops in general. We're talking about watch list cause police stops that happened to Sadiq Long. And the watch list cause police stops that happened to Sadiq Long are not speculative. They're not something that happened to somebody else. Also, in El Hadi talks about the fact that we haven't showed that this interferes with anybody's line of work. Here, Sadiq Long is a truck driver. Truck drivers need a hazmat license to carry even, normal.
I think the standing inquiry has to do with whether it's the independent action of a third party, not before the court, right?
Well, Your Honor, the independent action of the third party would regard the traceability element of standing. So if the independent actions of a third party comprise like an intervening event, then yes, Your Honor, I would agree with that legal point that it would break standing. But here, it's very predictable what a local police department will do when the FBI tells it that it's dealing with a known or suspected terrorist and doesn't even pay it the courtesy of telling the police officer whether it's a known terrorist or a suspected terrorist. In that situation, the independent acts of the third party, Oklahoma City Police Department, are predictable. Of course, it's going to take a heavier hand to a police stop involving a known or suspected terrorist than a police stop that they just did for speeding. Similarly,
But they didn't do that in every case, right? So if your point is that it's so predictable that it's traceable and redressable by our action, it seems like that would happen in every single instance where he interacted with the police, right?
yeah, and I think Fickrey addresses this point specifically, that this is the defendant's burden. The defendant's burden to show the
To
mootness.
show standing?
Well, no, Your Honor. The standing is there. The standing, in that case, the cause of the stop, the cause of the cessation of the Oklahoma City Police Department was another lawsuit filed by Sadiq Long. If Sadiq Long had not filed that lawsuit, the Oklahoma City Police Department would still be doing exactly what it had been doing.
And you all signed a stipulation to stop the conduct, is that correct?
A case-specific stipulation that lasts for the duration of that case. Basically, an agreed-to preliminary injunction. And just like a preliminary injunction, if granted, would not moot a case, we don't think that a stipulation in the Oklahoma, between Sadiq and the Oklahoma City Police Department would moot the case. And even if Your Honor feels that the issues with the Oklahoma City Police Department have been resolved in some kind of way, that still leaves every other police department receiving the copies of the watch list. And Sadiq Long, being a truck driver, that's where he works. He works on the road and is subject to those issues. And I think here...
So I guess your argument is for some type of perspective or future injury on the standing?
It's both. It's ongoing injury and it's future injury.
Well, in terms of the Oklahoma City Police Department, it seems as if that's been resolved by the settlement, right? And then this new policy regarding training and stopping him, seems like that's been resolved?
No, Your Honor, even after the stipulation, there were additional stops, because what happens, and this is proliferating throughout the country, local police departments are more and more relying on automated license plate readers. And so they're taking the person completely out of it, and they're just leaving it up to the computers. And the computers themselves are screening people against the watch list and telling officers what to do with the people that they encounter. And I think this quote from Fickrey helps here. It's about the passage of time, and I think Your Honor is getting to this point. It is the defendant's burden to establish that it cannot reasonably be expected to resume its challenge conduct, whether the suit happens to be new or long lingering, and whether, this is the key part, whether the challenge conduct might recur immediately or later at some more propitious moment. That's the issue here, Your Honor, that these harms could replicate again as they have previously, and I'll save the rest of my time for rebuttal. Thank you, Your Honor.
Thank you, Mr. Evans. Mr. Waldman?
Good morning, Your Honors. Joshua Waldman from the Department of Justice for the defendants and cross-appellee. The district court lacked statutory jurisdiction over plaintiff's no-fly list claim. Both the Ninth Circuit and the DC Circuit have held that those claims are within the exclusive jurisdiction of the Court of Appeals under Section 46.110. TSA makes the ultimate decision It has the authority to make the ultimate decision to maintain a person on the no-fly list at the culmination of the redress process. Plaintiff's complaint challenges that TSA final order. And for that
But
reason.
that's not the final order anymore, right? That was the final order, but then TSC issued its own order, and its letter says this replaces the decision made by
Right.
the administrator.
But the plaintiff's complaint, plaintiff's challenge, which he says is not moot, and I can address mootness in a moment, but his challenge is not to the removal. The removal is not an injury. His challenge is to the TSA decision to maintain him on the list. And that decision is a TSA order.
It is kind of sticky, right? Because the Supreme Court told us it's not moot by virtue of being taken off the list, but then the reasons they gave were because they said, well, it's because he's really challenging being placed on the list. Now you can phrase that as placed on or maintained on, right? Or he could be put back on, but the administrator, as I understand it, can't do that. The administrator can't put him back on the list. Only TSC does that. Is that correct?
That's correct. But under the theory of mootness, and we don't think the case is moot, but we don't think you need to reach that, and I can address that momentarily. But if you assume that it remains live, what the live challenge would be is to TSA's order, not TSC's order. And for that reason, it's an order that falls under 46.110, and that challenge must be brought in the Court of Appeals, and therefore the district court lacks statutory jurisdiction. We think you can cleanly resolve this case on that grounds without reaching mootness, although I'm happy to address that issue as well. I think that as the DC Circuit held in Moharram, which is the first Court of Appeals to meaningfully interpret FICRA post the Supreme Court's decision, they put challenges into two categories. One which they think fall under FICRA and one which does not. The first set of challenges are people who say that their placement on the watch list is due to some categorically impermissible, unconstitutional reason. And the second category are people who merely say the administrative record is not sufficient on the facts to meet the standard as that record exists today. We think that this case belongs in and Moharram said that second category, that claim is moot because there is no effective injunctive relief that could preclude the government on a new set of facts.
Well, Moharram was an actual petition for review of the administrator's decision, right? That properly followed the channeling requirement to take those claims to the DC Circuit.
That's correct, and we think that this case should also have properly
And that's why the
followed.
court could say, we're just reviewing the administrative record on the decision about this particular individual. It's not a broader challenge saying people are inappropriately placed on the list for discriminatory reasons.
Right, but I don't think that its decision followed from the fact that it was reviewing it under a petition for review as opposed to an appeal from a district court judgment. I think what they were saying is what matters is the nature of the claim. And when the nature of the claim is something is categorically impermissible, a court can afford effective relief. And the reason for that is a holding that a piece of information cannot be considered by TSA or the agency at all would have effective preclusive relief going forward because it would be just as impermissible in the future as it was in the past. Whereas an assessment about the sufficiency of the evidence would not have that same kind of preclusive
Doesn't this case
effect.
kind of have both? I mean, if we said you have to send this to the 10th Circuit or the DC Circuit, who would they order to do what, right? The administrator has not made the final decision in this case anymore. There's a new decision. And what would that court order, who would they order to do something?
Right. Well, I think there's a lot to that question that I'd like to unpack because there's a lot of different ways that you could come at it.
Right.
The first is to say, in this case, what the plaintiff tried to do and what they've argued here is that they're making a categorically impermissible argument, that he was put on the list for impermissible religion or nationality-based reasons. And the district court found that the complaint was utterly devoid of any plausible allegations of that nature relating to this specific plaintiff. He talked a lot about other people and what might happen to them, but he did not specifically relate it to him. And that's different from Fikra, who had an allegation that was plausible in his complaint, that he was put on the list based on religious affiliation, because as he contended in that case, and we're taking his facts as true for the moment, Fikra contended that he was asked in an FBI interview about his attendance at a mosque, and he inferred from that his listing status was based on his religion. And the Supreme Court said, therefore, his claim was about constitutionally impermissible conduct that was plausibly alleged and tied to him. We don't have that in this case. So effectively, all we have is a request to review the watch list status, the no-fly list status made by the administrator based on the administrative record before him at that time. And that is something that I think falls under Muharrem. But again, although I think that makes the case moot, I think you can just decide it on the statutory jurisdiction question and not reach the mootness question. But Judge Rushing, your question also sort of assumed that we no longer have a final decision from the administrator at this point. I think in the real world, the practical effect, that's correct. But from a mootness point of view, the argument that the claim remains live is a claim challenging the TSA administrator's decision as it existed at that time. And
I'm not sure about that. I agree it's confusing how mootness and the statutory jurisdiction work together, but I didn't read the Supreme Court as telling us, like, pretend that this thing that happened in the real world never happened. They're saying that thing happened, but it doesn't moot the claim because it could happen again, right? He could be placed back on the list for the reasons he's complaining about.
Yes, but I still think my understanding is that would mean that because the claim is live, what that challenge would entail is a challenge to the TSA administrator's decision and not some decision in the past, which I think that that's true because what I imagine the plaintiff ultimately wants is something that would help him in the future. But an evaluation of the lawfulness of a decision made allegedly 10 years ago doesn't necessarily tell you, doesn't provide any relief for what somebody might do today or 5 years from now on a different record. And I think that's one of our points. And the other thing that I would say is when he filed his complaint, he had not yet exhausted or gone through the redress process at all. And there was, by agreement of the parties, including from the plaintiff, the case was stayed for the specific purpose of going through the administrative redress process to obtain a final decision from the TSA administrator. And that's why we think what the challenge is, in fact, is a challenge to that final order, and that is why it belongs exclusively in the Court of Appeals under 46-110. I'd also like to sort of address some of the other watch list claims, if I may.
On the watch list, you
Yes.
sent us these letters from TSA to the plaintiff. Does the government still contend after those letters that the licensures, the hazmat licensures and TWIC, that those aren't an injury traceable to the watch list, or does the government changing its position in light of these letters?
Well, our argument is modified a little bit, but I think the outcome doesn't change. We still think that the claim fails for lack of standing and on the merits. And I'd like to address that, but before I do, I just want to talk about the factual situation about why things are under seal, because I think you might want to sort of understand what that situation is. So the plaintiff, the TSA issued these letters and sent them by certified first-class mail to the plaintiff at his mailing address, as you can see from the letters themselves. Plaintiff is not represented by counsel in those proceedings as he is in this appeal. And for that reason, TSA can't just send them to a lawyer who represents the plaintiff in another matter. So we reached out, when the letters were issued on Friday, on Monday, I reached out to opposing counsel and told him of the existence of the letter without describing its contents, explained that, as I just said, we couldn't just give him the letters, but that he would probably want them, and we provided a form that his client could fill out and sign and return to us, authorizing them to be his representatives in those administrative proceedings, at which point we would send him electronic copies of the letter. But the plaintiff's counsel has not yet responded to that request, So we have not been able to give him that material, although we would as soon as he fills out that letter, or of course plaintiff, as he receives it, is free to turn it over as well. And for privacy reasons, we just didn't want to just put it on the public docket without the plaintiff's consent. We also reached out for plaintiff's consent on that issue and have not received a response. If the plaintiff consents to putting it on the public docket, we have no opposition to doing that or to providing it to plaintiff's counsel. So I just want to make that point absolutely clear. To return to your question about how that affects the outcome of this case, you know, I'll speak in hypotheticals about what the letter might say in order to, you know, keep it under, you know, not break the seal, so to speak. It could really only do three things. One is keep it in similar posture as it is now. Therefore, in other words, no decision has been made, in which case our arguments are the same. It could grant the applications, in which case the injury as alleged sort of disappears and falls out of the case, or it was not granted, it was denied. In that case, it's my opposing counsel said that would be a final order. That is not correct. Under the regulations, if the TSA letters did deny, it would be a preliminary determination that the plaintiff would have 3 levels of administrative appeals, first to the assistant administrator, then to an administrative law judge, and then to a final decision maker, after which there could be review in federal court, again under 46-110, because that would be a TSA order. So for one, just to jump to the merits argument, it would not be a final decision, nor would the due process claim, I think, have any chance of success, since there's a lot of process that he could have.
This kind of brings us back to your statutory jurisdiction argument, right?
Yes.
If someone is granted or denied one of these licenses, that's a final decision, you know, eventually, once you appeal through it, it's a final
Yes.
decision by the TSA administrator, and that has to be
Correct.
channeled to certain courts. But isn't there a distinction between challenging the decision to get the license or not get the license versus challenging being on the watch list and saying, you know, I shouldn't be on the watch list, and one of the injuries that the watch list causes me is how it affects processing of these licenses?
Yes, and we think, I agree that if you're just trying to challenge the watch list as opposed to the decision, that you have a different statutory jurisdictional analysis. But here, the district court didn't rule on that basis, it ruled on an Article 3 standing basis. And our view is a decision by TSC on the watch list versus TSA with regard to these applications are 2 different decisions by 2 different agencies under 2 different standards. And there's a causation and redressability problem for that, which is that one doesn't necessarily or even likely cause the other.
Is that true? I've looked at the statutes for what TSA considers when it considers whether to grant or deny these licenses, and various security databases are one of the things they consider, isn't it?
Yes, but the only reason why, they look at many things. Some of them have nothing to do with any list at all, like a list of disqualifying criminal offenses, although you check a criminal history background list for that purpose. But the only reason why you would look at either the watch list or any other list is to point you to the underlying information or intelligence that might exist about that person, not the status in and of itself. And any judicial order that said, for example, remove someone from the watch list would not erase or negate the existence of that evidence. TSA would still look at that evidence and still make its own independent determination about whether it met the application standard.
So you're saying the government will do whatever it wants to do, no matter what the court rules?
Well,
That's basically what you're saying?
well, I'm saying that nothing, no court ruling about the TSC's decision would necessarily would not have any preclusive effect on TSA analyzing the same evidence for a different purpose under a different standard and reaching a different result.
You just said exactly what I said. Basically, once you put this albatross around someone's neck without any trial or any due process and no-fly list and impacting in Oklahoma being stopped by police, you're saying that it's on there and so it just stays there, or you can look at it?
No, Your Honor, what I'm saying is the way you would do it is not by challenging the watch list itself, but if you had a problem with with TSA's decision with regard to the hazmat.
How many years
and-
has this been going on since it put on the no-fly list? How many? How long? This is just a temporal question, that's all.
Right,
It's
we,
not analysis.
yeah, we don't, there's,
This is a temporal question, how long?
okay, I can't say that, Your
Oh,
Honor.
you don't know that from the record, how long he's been on the
It's
fly
because-
list, no-fly list?
Because the exact date when someone put on the no-fly list
Okay.
is privileged information, Your Honor.
Or it's
Yeah.
privileged?
Yeah, it's considered law enforcement sensitive and sensitive security information. So that's not part of the record.
So you can just label somebody and just say, well, we don't have to tell you, court, why we put him on there. He just has to suffer through being stopped, being ruined his whole life.
Well,
I mean,
if you
is
want.
that what you're arguing for the court?
No, Your Honor, you just asked me a historical temporal question, and it's privileged, so I can't say it in open court, but if we got to a point where we were actually adjudicating this on the merits, we would file a record, part of it would be under seal, and Your Honor would have access to it, and you would be able to see that exact information. I'm just saying I can't say it publicly because it's privileged information. And so all of these things, none of what we're saying is an argument that things are unreviewable, that you can't have a court look at it. We're just saying that there's certain ways to do it, and what they want to do is effectively have review of TSA's decision, not by challenging TSA's decision, but by challenging TSC's separate and different decision. And our view is, well, that's not going to change TSA's answer. So if you want to change TSA's answer through federal court action, then challenge TSA's decision. When you get a final action, go through the administrative process, and if you don't get the relief you want, file an action in this court or an appropriate court of appeals under 46-110, and you'll get judicial review. And if you think that the TSA has made a decision that's unlawful, you can say so.
So there's no time limit on when you might make a final decision?
No, except, but if they want to, those,
So there's no time limit on when you make a final decision, is there?
well, if they think that.
Can you answer that? Is that privileged too?
No, I don't think that, well, ultimately, there's a time limit. Because
Is there a time limit on when you can make a final decision? Is
there's
there?
nothing in the statute.
The answer is no, there isn't, isn't there?
Well,
Wait, why don't you just
no,
answer the question rather than just beating
I'm-
around the bush?
Your
The
Honor,
answer is no, there is no time limit. Is that right?
no, Your Honor.
Okay, there is a time limit.
Well, the plaintiff can bring an action for agency action unlawfully delayed. And if Your Honor comes to the conclusion that the agency is taking too long, you can issue an order. But under the statute regulation, no, there's no time limit. But I will say this, once an initial decision goes out, if the plaintiff wants to forego the administrative remedies, which are not required, he can wait 60 days and it'll be a final order, and then he can bring an action. So if what the letters we sent out were initial decisions, if that's what it was, he can wait 60 days and file an action. So at this point, he can do that. So if timing is a concern to him, you know, that's a pathway that he can take. Or if it had been a concern to him previously, he could have brought an action for mandamus or agency action unlawfully delayed. And if you thought we were taking too long as a matter of law, you could have ordered us to speed things up. But the plaintiff didn't do that. So our point is not that if you're unhappy with something, we're not saying you never have remedies. You do have remedies, but you have to bring them in the proper way, withstanding and attack the decision that you're actually unhappy with, and not try to end run by getting some other agency's order that you think is going to have some sort of effect on the final action or non-action that you're actually unhappy with.
Let me ask
our
you
only
a
point.
quick question, I guess procedural. If this court was to decide that the district court did not have jurisdiction based on FICRE, then it would need to be transferred to I think he's from Oklahoma, so 10th Circuit or the DC Circuit. Which court do we send it to?
Well, a couple things. If you thought there was no jurisdiction because of FICRA, I think that would be a mootness holding, in which case you would not transfer it anywhere because the case would be moot. If you agreed with us on the statutory jurisdiction under 46-110, then that issue would arise. And in that case, it's our view that if you agree with us, you should just affirm the dismissal by the district court and not transfer it. The plaintiff has not asked for a transfer from this court in his opening brief, in his reply brief, and it's sort of up to him to do that. So we think the easiest way would just be to say, he hasn't asked for a transfer, the district court didn't have jurisdiction, statutory jurisdiction, so we affirm the dismissal. And that would that's what we think is all you need to do.
Well, I guess what
But-
I'm asking is if it's not moot
Yes,
and the district court does not have jurisdiction, right? Because of the TSA claims.
Yeah.
Do we send it to DC Circuit or do we send it to the 10th Circuit?
well, I think if you get to, again, I still think that if you felt that the district court didn't have jurisdiction either as a statutory matter or as an Article 3 matter, because the plaintiff hasn't requested any transfer, that you don't need to do that. But if you disagreed with me and thought, well, I need to transfer it somewhere, we think the best venue would be the DC Circuit. It's the one where both parties' counsel are close to, and it's the one that is most familiar with handling classified and other privileged evidence of this kind of nature. So that would be the appropriate place to do it. It would be a little bit odd because I think under its own precedent in Moharam, the case would be moot. So you might want to sort of deal with that question first, but that's where, if you had to transfer it, that's where I would suggest that it go. But I do think also it's important to emphasize, and I know the amount of time, so if you prefer that I not go on, I won't, but I do want to emphasize that the watch list claims are separate from the no-fly list claims. And the mootness argument as it applies to no-fly list, there's no mootness argument with respect to the watch list. Those are standing arguments, and the statutory jurisdiction argument that applies to the no-fly list claim does not have any application to the watch list claims. Those fail for lack of standing, and they fail on the merits. So those are two different arguments. I just wanted to make that clear. I know that I'm well over my time, so if you don't have any other questions, I'll save the rest for my rebuttal.
Thank you, counsel.
Okay, thank you.
Mr. Abbott?
2011, Your Honor. That's when we believe Sadiq Long was placed on the no-fly list. It was in 2011. He found out later that year he was on the no-fly list when he tried to visit his grievously ill mother. He tried to travel from Qatar to Oklahoma, and that's how he found out he was on the no-fly list. The government sent him to the embassy to not fill out any appropriate paperwork, and it took a public campaign to get him on a plane back to the United States. And so I think that's where I want to start with just the mootness question about the no-fly list. And Muharram is explicitly distinguishable from Fikre in this case because whereas Muharram explicitly, quote, does not challenge the lawfulness of the agency's criteria or its reliance on any category of information, Sadiq Long does both of those things. He says that his claim is that there's no under substantive due process, they would have to use the least restrictive means to further a compelling interest if they are going to deprive him of his right of movement. And they don't need to do that to people that have not been arrested, charged, or convicted of any terrorism-related offense. And the fact here is that Sadiq Long flew twice while he was on the no-fly list. The fact that the government allows people on the no-fly list to fly is an indication that it's not the least restrictive means. They administer, it's called a one-time waiver process. They allow people on the no-fly list that are stranded abroad to come back to the United States one time on an airplane. They actually let Sadiq do it twice. If they can do it, if they can do a one-time waiver, then they can do a two-time waiver. If they can do a two-time waiver, they can do a five-time waiver. And so the least restrictive means are evident in what the government's practices are. And we just have allegation after allegation after allegation about the religious profiling that's at the center of this watch list. We catalog 10, 12 examples of the watch list not being used to protect aviation or protect this person or that person, just being used to recruit informants to comprehensively surveil the Muslim community. That's what happened to Sonic. That's what happened to Jonas Fikre. That's what happened to so many, most of the litigants challenging the no-fly list. So For the reasons that Muharrem sets aside, that you can bring a claim that the no-fly list is categorically impermissible facially, that's what we're marching through. With regards to 46110, we are challenging the Terrorism Screening Center's decision to place Sadiq Long on the no-fly list. They made that decision in 2011. That's what we believe. In 2016, it was the Terrorism Screening Center, it wasn't TSA, that made the decision to remove them from the no-fly list. It's the Terrorism Screening Center's procedures, it's their criteria about who is included and who is excluded from the no-fly list, and we challenge all of that.
Are you
And,
challenging the adequacy of the redress process, of the trip process?
I think, Your Honor, I think that plays out differently in accordance to the claim. For the substantive due process claim, the redress process may be relevant to how narrowly tailored, or if they're using the least restrictive means procedures to administer the no-fly list. But I don't think that for the procedural due process claim here, it's the same procedures that existed when he was placed persist to today.
But the redress process was created by TSA, right? That's an order of the administrator.
Well, first, the statute that directed the creation of DHS TRIP directed the Department of Homeland Security to create DHS TRIP, and that's why it's called DHS TRIP and not called TSA TRIP, because that's where the statutory authority is. Your Honor, my speculation is that the reason they assigned the DHS TRIP final agency authority to TSA is just to benefit from 46110's jurisdictional channeling statute.
So do you agree if someone were to challenge the adequacy of the trip redress process? I think I just heard you say that's a process that's articulated by TSA administrator that goes through 46110.
Your Honor, although TSA plays a role in the TRIP process, and this is in their retelling of it as well, it's the Terrorism Screening Center that really is doing all the legwork about the
Hasn't the Sixth Circuit suggested that if someone's challenging the adequacy of the redress process, they have to have the administrator as a party to that suit, presumably because and they've talked about how there are orders of TSA that created that process?
I think if you had an adequacy challenge like you did in Muharrem that was specific to the plaintiff itself, that the TSA administrator looked at the evidence and balanced it inappropriately or gave credit where credit was not due.
No, this is different. This is a procedural, right? This is
Exactly.
saying, just looking at the procedures, these are inadequate to protect anyone's rights. We're challenging the order that created these procedures.
Yeah,
And the Sixth Circuit said, or highly suggested, that would have to be channeled.
Well, for example, Your Honor, the key thing in the administration of the procedures is the inclusion criteria of what the watch list allows to be included and doesn't allow to be included. TSA had nothing to do with the inclusion criteria of the watch list or the no-fly list. That's administered by the Terrorism Screening Center and the FBI. It was not decided by TSA. And so if TSA is just inheriting the Terrorism Screening Center's watch list and no-fly list inclusion standard, they're going to be hamstrung, and the process is going to be inadequate, not because of the particular procedures that TSA is doing, but because of the standard that they're operating. For example, if the inclusion standard, to give a little bit of a ridiculous example, if the inclusion standard for the no-fly list was everybody that has red socks, TSA could set up very effective procedures for determining who does and does not have red socks. But the problem there wouldn't be with TSA's procedures. It would be with the criteria that we're putting people on the no-fly list because of their red socks. Now, take out red socks, but because they're Muslim, because they associate with Islamic practices. And then you have this current situation here, Your Honor. And if there are no further questions, that's all I have. Thank you, Your Honor.
Thank you. Thank you, both counsel.
Thank you, Your Honor. I just would like to just address a couple of points. The first is the plaintiff's claim that this is about constitutionally impermissible basis for watch listing. The district court found, and this is a Joint Appendix 138, the court cannot identify any individualized facts directly in support of this claim, meaning the religion claim, and declines to consider it. And then again, on page 152, that the plaintiffs failed to discuss anywhere in their amended complaint it quoted some portion of the complaint talking about alleging a Muslim-based placing on the list, and he said there's nothing anywhere in the amended complaint linking that to the plaintiff. And that is the point that we are trying to make, that effectively, once that part of the case was found to have no plausible basis in the complaint, all we are left with is a question of whether the evidence in the administrative record would be sufficient to support a no-fly list decision. And that is why we're sort of in the same world as we are as Muharram, as opposed to FICRA.
So there's nothing in the record that associates him with being of the Islamic faith?
No,
No,
he does say that he has the Islamic faith. The district court's finding was that there's nothing in the complaint tying the no-fly list decision to his Islamic faith, to his particularly.
not the allegations of the frequency of or the percentage of people on the fly list in terms of being associated with Islamic faith? That's no evidence of it?
No, I'm not. That's not what the district court found.
I know it found, but is that, would that be even, have any semblance of what the facts are?
Yes, but he's bringing an equal protection claim, and the equal protection claim, this is not like a disparate impact claim. This is about an equal protection violation for him, which he would need to say his listing was based on some impermissible factor about him, and he hasn't given any basis for thinking that that's the case. That's plausible in his complaint. That's what the district court found. That's the reason why it dismissed the equal protection claim, and that's not contested in the brief. It's raised, I think, effectively for the first time here to try to revive that claim, and that's my only point, Your Honor. But again, even if you disagree with us and therefore think that we're not in Muharram and therefore the case remains live, we still have our argument that there was no statutory jurisdiction. And Judge Rushing, as you pointed out, the Sixth Circuit in the Mockdad case strongly suggested that a procedural claim belongs in the Court of Appeals. The D.C. Circuit in Busick held that both substantive and procedural challenges to no-fly list status belong in the Court of Appeals. The Ninth Circuit in Casham held that the substantive claim belongs in the Court of Appeals, and there has not been any Court of Appeals that I'm aware of since the redress procedures were changed 10 years ago that has held to the contrary, that these no-fly challenges to the TSA administrator's order belong in the district court. They all uniformly hold that it belongs in the Court of Appeals. And that is something that the plaintiff did not even dispute until his reply brief.
The case from the FICRA case, right, went to the Supreme Court and came back to the Ninth Circuit, and it's, as I understand it, that case is proceeding in the district court normally, right? That the Ninth Circuit didn't think that needed to be channeled to the D.C. Circuit.
The Ninth Circuit did an interesting thing that the Supreme Court wasn't actually before the Supreme Court, this particular issue. The Ninth Circuit agreed that if the person was challenging the TSA order at the end of the redress process, that would belong in the Court of Appeals, and the district court would have lacked jurisdiction. But what it said is this complaint, as it viewed that particular complaint based on particular facts and the way the complaint was worded, was a challenge only to the original TSC decision, and therefore they thought that claim belonged in district court because that was a TSC order versus a TSA order. Our view is that's not what this complaint is about. They asked to stay all the litigation to get a TSA order and then amended their complaint to make it clear that they were challenging the TSA order. So we're not in that world. We also think that on the merits, if all you're challenging is the TSC order, that is not final agency action once you have already gone through the redress process. The only final order that exists at that point is the TSA order, not the TSC order. We also think a due process challenge solely focused on the initial decision would necessarily fail on the merits for other reasons. For example, it would necessarily ask for pre-deprivation process, which no court has ever held is available under the no-fly list, and would mean, would have a whole host of consequences that I think would be unlawful. And it also would mean you would be bringing a due process challenge, even though you could, to an initial decision, even though there was available process to you in terms of the trip redress process. And a due process claim that says, I haven't been provided process, when there's available process you haven't taken the opportunity to pursue, means that your claim would necessarily fail. So if they were only challenging the initial decision, we think that they might get out of the statutory jurisdiction problem, but they would create a whole host of merits problems that would defeat their claim. And I'm happy to entertain any other questions that the court may have.
Right. Thank you, counsel.
Okay. Do I need one? Oh, no,
All right, we'll come down, Great Counsel, proceed to our next case. Ms. Kraft, are you ready?
Your Honors, and may it please the court, I've reserved 7 minutes for rebuttal. We're here today on the issue of a disability discrimination case against the Department of Army. We believe that the lower court made a number of different
Excuse me, I'll ask you to pull the mic down toward you a little bit. There you go.
Okay, sorry. We believe the district court made a number of errors in their decision, the first being the dismissal of the hostile work environment claim on a 12B6, and then the remainder of the claims being dismissed under a summary judgment under section 56, or under Rule 56, I apologize. I think the hostile work environment was, the court described it as a series of disjointed, uncomfortable interactions. When you look at the totality of the circumstances, which is what you're supposed to do, it was much more than that. It was a definite increase in microaggressions that caused the appellant to have panic attacks and to suffer from symptoms that she had not suffered from since being diagnosed with PTSD and anxiety. So we believe that that decision should be overturned, or should be reversed and remanded back to the district court to go through discovery. The disability discrimination, the interference, the failure to accommodate, and the retaliation claims were dismissed, as I said, on a section, on a Rule 56, and so those would need to be reversed and remanded for further trial. The disability discrimination claim, the district court analyzed that under a section 504. Section 504 does not apply to federal employment. Section 504 under the Rehabilitation Act applies to entities that receive federal funding, but Section 501 is specific to federal employment. And the reason that that is so important is because there are two distinct differences. The first is that under Section 501, you do have a right to a jury trial. Under Section 504, you do not. Under Section 501, the second distinction is you only have to show that the discrimination was based upon your disability. Whereas on a Section 504, you're required to show that the discrimination was based solely on your disability. And that's a huge distinction. When analyzing the differences between Section 501 and Section 504, it seems as if the courts are split among the circuits. This court in Hannah P. started out analyzing it under a Section 504, but did not make the disability analysis determination, instead jumped to the McConnell-Douglas analysis of whether or not the appellant could rebut the pretext.
So what is the evidence that the plaintiff's disability was a motivating cause of the discrimination?
We have a various number of ways that the defendant interacted with the plaintiff that she knew, the supervisor knew would increase the plaintiff's anxiety. She knew she had anxiety, she knew she suffered from PTSD.
Just knowing about a disability is not sufficient, right? We have lots of cases that say
Correct.
knowing about a disability doesn't suffice to show discrimination on the basis of the disability. So even accepting the lower motivating cause standard, what's your best evidence?
The best evidence is the way that the defendant treated Ms. Smith in the workplace. She did things to increase her anxiety, knowing that it would increase her anxiety. She would wait for her at her cubicle. The supervisor would wait for her at her cubicle when she came into work, knowing
Doesn't the evidence suggest that she did that because she didn't like people being late, and
that was after the appellant had already filed an allegation of discrimination and asked for accommodations. So it really didn't have anything to do with her being late. In fact, there really was little evidence that she was late. Her progress report or
Wait, what is the discrimination we are talking about?
We're talking about their attitudes toward her mental disability of anxiety and PTSD.
Like, attitudes aren't something you can sue over. You have to show she was discriminated against because of a disability. What's the discrimination that happened?
The discrimination was treating her differently. She didn't wait for anybody.
What's the adverse action, I guess is
The
what I'm
adverse
asking.
action is that it caused Ms. Smith not to be able to work. The increased anxiety amped up her ability to actually be at work. It increased the symptoms. She asked for accommodation. She asked to telework. She asked to be transferred. She asked for reassignment.
But I know she asked for accommodations, but there was, in her medical record, and I don't have the exact date, they said that there was no job that she could perform.
That was much later on in the process. And again, this becomes part of the prolonged interaction between the defendant and the plaintiff, in which she took short-term leave in order to discuss accommodations and what could be done. Those accommodations were never discussed. There was no interactive process. There was no discussion of how can we make this place appropriate for you. And that then increased her anxiety and her ability to come back. There were a couple of times that she was able to come back and she was able to work when she wasn't on the same floor as the supervisor, but that process was significantly hampered by the defendant's actions. The defendant took her computer away from her. The lower court said, well, if she's on leave, she doesn't need her computer. They did more than just take her computer away, though. They essentially wiped the computer and got rid of her emails and got rid of any evidence that she could use in support of the discrimination.
You listed off a number of accommodations earlier, like telework and things like that, but I didn't see in your brief that you disputed the district court's ruling that none of that was considered in the EEO proceedings, that was just transferred to a different supervisor was the accommodation that was requested, and then that's the only one that was exhausted in front of the EEOC.
The transfer to a different supervisor was the one that was most vocal and was most discussed, but in all of the EEOC records, there was discussion of, I've asked for everything. I've asked to be reassigned. I've asked to be transferred. I've asked to, to telework. I've asked to do all of these things.
So are you disagreeing with the district court's ruling that those were not exhausted?
Yes.
And where can I find that in your brief?
I will look at that and get that back to you on rebuttal. So we also are claiming a failure to accommodate, and implicit in the failure to accommodate is a failure to engage in the interactive process. There was nothing that the defendant did in order to interact with Ms. Smith to determine what could be or would be an appropriate accommodation for her. And although she was asking for reassignment, there's no question she would have considered other types of accommodations, but it was very clear that every time the subject was brought up by Ms. Smith or by representatives from Ms. Smith, it was met with, no, we're not going to have that discussion until later. First, there was a 15-6, which is an investigation of a hostile work environment. They decided that they would not make any decisions on disability or accommodations until the conclusion of the 15-6. Ms. Smith was never informed when the 15-6 was completed. The records show that it was completed sometime in July of 2012. That information was never shared with Ms. Smith, and one of the recommendations was that Ms. Smith be reassigned. That also.
So her, when she was placed on leave, you don't consider that as part of the accommodations due to her health?
That was never a discussion. That was never a discussion of an accommodation. She was never told, we recognize you have a disability, we recognize that you need an accommodation, here's leave of absence, here's a leave. The discussion was, we'll approve your leave, but we're not talking about disability until the 15-6 is done.
But but as a part of the leave, which I'll bring up again, I believe her doctor said that there was no job that she could perform. At least that's what her medical documentation is stating, so.
The medical documentation as of October made that claim because she was on short-term leave. It was a 2-week period. So every 2 weeks, Ms. Smith would go in and say, where do we stand with accommodations? What are we doing? How are we doing it? And it was, we're waiting on the 15-6. And she would go back to her doctor and say, they're not doing any accommodations, and the doctor would give her another 2 weeks. So it wasn't a long-term leave, as in she asked for 3 months or 6 months leave in order to recover. It was always very short-term leaves with the idea, from her perspective, that at some point there would be some discussion about what would be appropriate to allow her to return to work.
But you would agree that she was on leave for over a year?
Yeah, I agree that she ended up being absent before she was first considered AWOL and then considered retired for over a year.
And even in the administrative proceeding, right, there's a finding, complainant's medical provider would not say whether reassigning complainant would allow her to return to the workplace. So even if she received what she had asked, no one was willing to testify that even then she could come back to work, right? Her medical provider wouldn't say that even with that reassignment she could work.
And I think that, again, we're talking about time frames, so we're talking about when that medical provider testified and the degree of what had happened. And we're also talking about, I believe, if I remember the record correctly, the medical provider was hesitant to say, this is exactly what she needs to do, but rather was saying, we can give it a try. Let's try something.
I'm just reading what the administrative fact finder found when she was exhausting her claims in front of the EEOC.
Right, and we dispute that was what the medical provider provided testimony on.
So you're disputing that fact finding by the EEOC?
Yeah, that she could not,
Stated this?
yeah, that
on
she
the
could not
transcript?
perform any duties, that no job would be, she's not available for any job.
What's our authority to review that, and what standard would it be under?
You're not reviewing the administrative record. Or the district court, excuse me, the district court, the lower court, and I'm almost out of time, so.
You may respond.
Okay. The district court is charged with reviewing the record as a full, not reviewing what the decisions made by the EEOC administrative process
Right, that's
were.
why I asked the question. On what basis can we review this fact finding, and what's the evidence that challenges it? And what would our standard of review be? It would be
de novo of the record. Absent the EEOC, it would be the doctor's report, it would be the doctor's, the series of medical evaluations that were provided to give her short-term leave. It would be all of that put in context.
Now, you're not arguing that the intervals of granting leave made her condition worse, are you?
I'm arguing that the intervals were designed with the idea that this is short-term. And as the short-term went on and there was no solution, there was no interaction, there was no discussion of accommodations on the part of the defendant, that her anxiety level became higher. And then once you get to October, January, that's when you have a point where she was considered, we're not sure what she can do. We should give it a try, but we don't know exactly what the accommodation would be.
So you're saying that had they given her what she requested, she never would have had a leave extended? That's your view?
Yeah, correct. If they had engaged in the interactive process, she might have been out of work for a month while that was, put in place, and they tried out an accommodation to see if it worked. And then we all would have gone on with life.
Okay. Thank you,
Thank you.
counsel. You have time reserved. Yes.
Thank you.
Mr. Shields, minutes?
Thank you, Your Honors. May it please the Court, Tyra DeShields on behalf of the U.S. Attorney's Office for the District of Maryland, on behalf of the appellee. Your Honors, a fair reading of this record only confirms the soundness of the District Court's judgment in this case, that Ms. Smith failed to meet the essential elements of her claims, and that there was no triable issue of material fact and that the court is not standing in the position of letting unsupported claims and/or defenses go forward with the trial, and this court on its de novo review should reach the same conclusion. Let me start first with the failure to accommodate claim that really is sort of at the heart of this contention. Ms. Smith's request for accommodation was that she be reassigned away from Ms. Monger to a different supervisor, and that was the only properly exhausted accommodation-related claim before the district court and now this court. The district court specifically found, and it is also in the lower record because it was not included in the EEO complaint, that telework was never exhausted as a reasonable accommodation. And in fact, if you go through the record, you will see that when Ms. Smith made her request, she made a request for reasonable accommodation, asked to be reassigned when she was talking to Kelly Keck, who was the EEO specialist and also sort of the disability rights coordinator, and he referred her to the HR office. She spoke with Ms. Lyles, asked for reassignment away from Ms. Monger, and then when she put in sort of the more formalized written request for accommodation on October 8th of 2013, She wrote specifically that she wanted to be reassigned away from Ms. Monger, and that she preferred to have a permanent assignment and not a detail. And nowhere in there was there a mention of telework or a detail or an alternate work cycle. So the only thing that is before this court is whether she should have been reassigned away to, and whether that was a reasonable accommodation. And it was not. An accommodation is supposed to be pegged to assisting a disabled person with performing the essential functions of their job. And here, Ms. Smith's request was not sort of rooted in her inability to do an essential function of her job. And in fact, you just heard Ms. Appellant's counsel say that, well, maybe she could have done her job because she came to work a couple of times in between before she ended up taking this very, very lengthy leave that was granted to her by the Army. To hold that this kind of a request to just be switched from one supervisor to another under such circumstances.
Well, maybe you can help me with this, but
Yes.
and I'm not making any judgments one way or the other, because at this point we're not there. But it seems to me this is an accommodation that's a little different, I guess, than most. They normally come sort of in a hostile work environment situation. This is different. What she's saying is that her need for accommodation is 100% caused by harassing activity of her employer. Normally, it's the other way. It's health or some other reason. That's the sine qua non in this case, which, right or wrong, I'm not making a judgment. I'm saying, but that's what this case is. She's saying that I can do my job fine. It's just because I'm being harassed by this person, and I can't do that, and it's causing me anxiety and problems, and those things relate. That's what the related thing there. But if you stop doing this, then I can do that. So that's what her claim is. So I mean, so is it a question of whether or not, obviously you don't concede that she was harassed, do you?
No, I do not, Your
So
Honor.
that's a factual question for an allegation, isn't it? I mean, otherwise that's what she's saying, that basically, and that's why, in the sense that she was saying that there's intervals, there, I'm waiting for you to do something, and the waiting is waiting for you either to transfer me somewhere else and get away from this person. Otherwise, I won't be able to do my work. And then finally, I think their theory is that after a while, maybe I can't do anything. That's what the medical person was saying, because it's been so prolonged. Again, I'm not making judgment about it, but we have to first understand what the issue is. But see, like, that's the question, and that is, she says that I'm being berated and harassed and those things like that, and it's a hostile work environment and has turned it into a situation where I need accommodations. That's the claim. So, I mean, we got to first get the apples and the apples aligned. I mean, so am I wrong about in this, what she's saying? I'm fine. I would be healthy, fine. But it's who you're making me endure this situation with this person. And when I ask that you do something about it, you won't. So why you won't, I can do nothing but extend my leave. I mean, am I wrong about that? That's the theory in this case? Tell me that first before you answer that. Am I wrong? 'Cause I may be wrong. That's why I'm asking you. You know the record better than me. But
It
isn't that the case?
may be her theory of the case, but she was not subjected to a hostile work environment.
I know that's a factual question. I'm not making a judgment that she was. I'm just saying that is what this case is about, right? Am I wrong?
What this case is about, Your Honor, is whether she made a request for a reasonable accommodation, and also whether she actually met the elements to sustain a claim of failure to accommodate. This was not a case where the Army failed to engage in the interactive process. Ms. Smith was essentially unable to perform the functions of her job, and that started on April 29th of 2013, when she had this encounter with Ms. Monger that she says caused her to have a panic attack when her supervisor said that she was tardy for a meeting that she was supposed to attend with Ms. Monger and another individual. She was late to that meeting, and Ms. Monger called her on it to lapse into a colloquialism, and then she said that Ms. Smith said that she had a panic attack, and and then from there she actually went to patient first. And if you look in the record, there's a doctor's note from Dr. Mendoza, who indicated that Ms. Smith was diagnosed with panic attacks, with anxiety, and that it was indefinite until further evaluation as to the nature of the duration of her condition. Ms. Smith did return to work on April 30th, on May 1st and May 2nd to attend some sort of retirement training, planning, or some such, and then came to work on a few isolated occasions in May before she submitted her request for voluntary leave, for participation in the voluntary leave transfer program on May 16th. And the agency granted, or the Army granted that request, and thereafter, Ms. Smith just continued to ask for more and more leave. Now, it is true that the Army said, initially said that with regard to the reassignment itself, they wanted to do this internal investigation to basically to find out the facts and to determine what was appropriate. And the Chief of Staff, Karen Taylor, made that, quote unquote, a top priority. That's there in the record, and she directed that the internal investigation be completed as soon as possible. And it was. It was started in May 7th, and it was completed on July 11th. And all through that time, Ms. Smith was the person who was asking for leave, and she was granted leave. And finally, she was submitting notes, and none of those doctor's notes suggested that she was in any way or in any way capable or shape to perform the essential functions of her job. This was not a situation where, oh, if you just assign me over to here, I will be able to perform the job. Ms. Smith, I will point out to you, also applied for disability benefits. She submitted documentation when she applied for the voluntary leave transfer program, and also when she was seeking leave without pay, all of which said, same doctor's notes, that she was not able to perform the functions of her job. And then Dr. Glanville, this was unfortunately the doctor's note that she supplied, or the report that she supplied in connection to questions that were put forth to her by the Army, is undated. But what she indicated in that report was that Ms. Smith was unable to perform any job. She had short-term memory, cognitive impairment, she could not concentrate, she had lapses in attention, she suffered panic attacks, and I stress to you, she said again, she will not be able to perform any job, any function of her job. And it is simply not in accord with the record that Dr. Glanville said that, oh, well, let's just wait and see as to whether or not the reassignment will allow her to perform the functions of her job. What Dr. Glanville said is that I won't speculate as to whether her condition will improve with reassignment. So what is the Army supposed to do in that case is they're trying to figure out whether a reassignment will work for this person or whether there should be some alternate solution that's applied. Ms. Smith was on leave for well nigh close to a year, and the agency still granted her leave without pay extensively, finally made the decision to put her on AWOL status because it was mission essential. She had to be able to do the job. She wasn't able to do the job. So she was not a person who is otherwise qualified, and so she doesn't satisfy that element of her failure to accommodate claim, even if you don't find that her request to be moved to a particular supervisor isn't, something that is, as a matter of law, is not a reasonable accommodation.
Counsel, when did she first make a request to be transferred to another supervisor?
I believe she made that request when she met on the same day as the encounter, April 29th of 2013, when she met with an individual by the name of Kelly Keck.
Right.
She said at that point that it was not in any way attributable. She couldn't figure out she did not know that there was a basis rooted in discrimination for it. She just wanted to be transferred. And Mr. Keck referred her to the HR individual.
I thought it wasn't really clarified until the fall whether this was an accommodation request,
and that is
there was initial sort of personality disagreements. There were informal requests at the office. There was the statement, I don't have a basis for thinking there's any discrimination behind it. But then Mr. Keck in, it looks like September, specifically asks, are you making an accommodation request? And then a couple days after she says yes, then he followed up with, well, we're gonna need this particular medical documentation, we're gonna need, to follow up on that accommodation request and participate in that process. And then she provided that information in December.
That is correct, Your Honor. All
So-
of that is correct, is borne out of the
Okay,
record.
I'm losing where the lack of, they argue that the Army didn't participate in the interactive process, but it looks like that process begins in September when she formally requests an accommodation.
When she makes formally requests, because up until that point, it was equivocal, ambiguous as to whether or not that doesn't count under the law, that the employer is sufficiently put on notice that the person is requesting a reasonable accommodation. So when in September, she makes that request to Mr. Kelly Keck, and then she starts submitting the documentation in support of it, that is when, the agency is also trying to figure out what can we do? What can we do about this? Please keep supplying each time that she applied for leave. Please please show us the documentation that supports whether or not you're able to return to work. And that documentation just simply was absent up until the point that the Army had to make the decision for mission critical purposes that she would either be put in an AWOL status, and if she did not return to work, she would be put in an AWOL status. And even then, when she was put in that AWOL status on January 6th of 2014, the Army didn't make the decision in the form of a notice of proposed removal until March. So she was given plenty of time to demonstrate that she could return to work to perform the essential functions of her job, and simply the evidence, she did not.
So I guess it's your position that when the request for accommodations, I think she was October 8th or something like that.
That's the
During
written
this-
request.
During this, her formal request for accommodations, during the same time, you had a letter from her doctor saying that there's no job that she can perform.
Correct.
So because of the medical documentation, there's no job that she can perform, then even sending her back and changing her supervisor would not matter because the doctor says there's no job she can perform.
Correct, Your Honor. That is correct. And let's keep in mind, too, that the strongest, most compelling evidence on this point comes from Ms. Smith herself in the form of the doctor's notes that she supplied. And indeed, in her deposition testimony in this case, during the discovery process at the lower court level, the district court level, in January of 2023, she said that she still was not working simply because she did not want to have, or she was afraid that she would have another supervisor like Ms. Monger, who, by the way, I think, just to revert to the hostile work environment claim, this case is on a spectrum, I think, that's closer to DaCosta versus Becerra than it is to anything else. And there, if you'll recall, that was a situation where DaCosta supervisor, she said, treated her disdainfully, spoke to her contemptuously, put her on what would be considered a performance improvement plan, gave her sort of a letter of expectancy about what her performance should be, and said that, would meet with her, berated her and whatnot. And this court there said that that was not sufficient to establish severity or that it was pervasive, and so that element of hostile work environment was not met. And that is the same case here. Ms. Smith's, all of the things that she catalogs as contributing to a hostile work environment are really can be cataloged or captioned under the heading of, this is just simply a personality discord between two individuals, a supervisor and a subordinate. I see that I have about 5 minutes left in my time. I just simply also wanted to touch on, Your Honors, the interference claim. And with regard to that interference claim, I think that it fails for two reasons. First, the record evidence does not show that the acts complained of by Ms. Smith as constituting interference or intimidation were actually done on account of her protected activity. And that is to say that these acts would have been undertaken to thwart her participating or engaging in protected activity. And secondly, there's no record evidence that supports an inference that the acts complained of were actually motivated by an intent to discriminate. Now, Ms. Smith seeks to fill the gap with these unsupported conclusions that are basically mere surmise and which the law does not and should not countenance as sufficient to make out this kind of a claim. And moreover, to accept Ms. Smith's interpretation of what is interference or intimidation, for example, this perceived delay in responding to the reassignment accommodation request, Ms. Monger stopping by her desk in the morning and keeping a work schedule that's similar to Ms. Smith's, the deactivation of Ms. Smith's badge and access to her work computer while she was on extended leave, would do what is explicitly not envisioned by the interference standard, which this court discussed but did not expressly adopt in the Kelly versus Town of Abington case. You would basically be turning any action that whatsoever in any way, however tenuously, hinders a member of a protected class into some sort of interference or intimidation, and that simply can't be a logical extension of the law. And in fact, the Army's actions in this case cut against any finding that it tried to prevent Ms. Smith from exercising her protected rights or did so with an intent to discriminate. And a fair reading of the record shows that the Army repeatedly requested updates on Smith's medical status to determine what could best be done regarding her accommodation request, and it accommodated her over many months by authorizing the leave that she requested. In sum, the record simply fails to generate a triable issue of material fact respecting the interference claim or any of the claims dismissed on summary judgment or on the Army's motion to dismiss. And with regard to the retaliation claim, I will just say that the district court did not misapply that standard with respect to retaliation. The district court followed what was this court's understanding of Burlington. And in Burlington, of course, what was discussed there is what constitutes a materially adverse action is something that would dissuade a reasonable employee from engaging in protected activity or making a charge of discrimination. And what the Supreme Court said in Burlington in trying to sort of flesh out, well, what exactly does materially adverse actually mean? It set up the construct. We're not talking about minor, trivial things. We are talking about significant harm. And that is something that this court discussed at length in the Israelite opinion, and which the district court followed faithfully. And if there are no other questions that are to be asked by the court, I will yield my time and simply ask that you give a fair reading of the record, and when you do so, you will be compelled to award judgment or to affirm the judgment of the district court in this case.
Thank you, Counsel.
Thank you, Your Honor.
Ms. Kraft, you have some time reserved.
Thank you. I first want to begin with the interference claim that counsel just spoke about. Well, let me back up. I apologize. The Army is making a very clear distinction between an informal request for an accommodation and a formal request for an accommodation.
Well, it seems to be tied to making the connection that it's an accommodation for a disability, right? I think the district court called it making the logical bridge, so that the Army knows, oh, now we're in accommodating a disability territory, and there are rules and procedures we have to follow when it comes to that. So it may not be so much as formal versus informal as it is this a request, is this an accommodation for a disability that's being requested, or are we being presented with an employee who's requesting a change in their position for some other reason?
Sure. So
When was that logical bridge created? When did the plaintiff explain to the Army that I'm requesting a different supervisor because of my disability?
And I think she did that shortly after April 29th. I believe it was on May 2nd or May 7th. I may have the dates mixed up. She submitted a fairly lengthy letter to Carrie Keck, who was the disability coordinator for ATEC, for that chapter chief division of the Army. And she did not say, I'm requesting a 15-6 hostile work environment. I'm requesting an accommodation. She didn't use any terms that should have delineated that into any category. She listed things that were happening. She listed the fact that she had a disability, that she had PTSD and anxiety, and that the work environment was.
And what was, when was that she listed the diagnoses?
That was in the May communication to Carrie Keck.
Was it the May 2nd email? She said, I had a panic attack.
No, there's one where she attaches to a to an email communication to, because Mr. Keck gave her information. He said, write up what happened, give it to me. So she wrote up a memo of what happened and what she was asking for. She did not say, I'm asking for a 15-6 investigation to be done, you know, to determine if Ms. Monger, you know, somehow acted inappropriately. She simply said, I have a disability, I have PTSD, I have anxiety, and this is what's happening to me, and this is the consequence. So because of Mr. Keck's role as the disability manager in the EEO department of ATEC, he had the discretion, and it's my understanding, we don't have his records.
Can you give me a site for that? I mean, I'm seeing this email saying, you know, I had a serious panic attack on April 29th and had to take some medication, missing work due to my anxiety. Where is it that she says that I have a disability and I need an accommodation for it, or even something close to that?
It's in, is that a memo format, or is that just an email that you're reading from, the May 2nd?
It appears, I assume it's the email that she sent.
Okay, there's a memo that is throughout.
What's the JA site?
Yeah,
Hmm?
tell us where it is on the record.
Yeah,
Okay,
that's,
I believe it is going to be. I have a series of sites, JA 559, JA 885, 254, and 276.
And which one of those is the memo?
I'm not certain which one is the memo.
Want to take a look and
That's
tell
pretty-
us?
you said 5.5, what was the first one?
559.
559.
Mm-hmm.
It's like, it's like a transcript.
Yeah, that's a
It's a
transcript.
transcript.
That's a transcript.
Okay.
885 is the
I can-
EEO proceeding.
I can find that one.
Counsel, this is critical to your case.
I understand. I understand.
That's the EEO proceeding. And then this is a September email. So I don't see a May memo in any of those. I looked at those 4 citations.
Well, Counselor, if you can't find it, I know you don't have a lot of pressure there to try to find it, but if you can't, there is a 28J
Yes.
procedure that we have.
Thank you.
And I suggest you avail yourself of that if it exists. So you're saying that it does exist?
Yes, it does exist. There is a memo that she gave to Kelly Keck, who then referred her to HR.
And she advised them of her condition,
Yes.
right?
Yes.
And that's not in September?
No, that was in May.
All right. I didn't find supportive citations for many propositions in your brief. So if there is a supportive citation for this one, 28J would be a good idea.
Thank you.
Right.
The informal and the informal process, again, it's that delay between what happened. And there are many times in which HR or Kelly Keck, EEO, contacted the supervisors and said, are we going to look at accommodations? Are we going to move her? What are we going to do? And the answer was always not until the 15-6 is completed. And I think that would thwart any reasonable person from continuing to ask for. So that goes to the interference issue.
Ms. Kraft, can you address this in terms of, and I think I asked counsel, your worthy colleague was very detailed about what she says in terms of run line. So, but as I understand it, she cited one incident that was something about your client coming in late or something. Somehow there was a situation, an encounter, as whatever that is, that event.
Mm-hmm.
And that's the only one cited. Then the rest of it is sort of what happened after that in terms of your. Are there other instances other than that one day that would be the basis of what you would call, as you say, triggering events?
Yes, there was an incident in February in which she berated people in front of, or she berated Ms. Smith in front of her colleagues. There were many.
Berating is a nice big word, but it's a word that people like me, like just common, sort of people, just everyday people. What does that mean? What did she do?
It means that she questioned whether she was reliable, questioned whether she was doing her job properly, questioned whether she wanted to work for her job, made comments such as, and directed it towards Ms. Smith, such as.
In front of other people.
In front of other people. And one incident on the 29th was in front of not someone who was working with the organization, but not within Ms. Smith's organization.
Let me ask you this though, because you have a disability discrimination case and a hostile work environment based on disability. How are you connecting this behavior by the supervisor to her disability?
We're connecting it because
did she say something that regarding the disability what did she do in terms of the discrimination? What did she do in terms of the hostile work environment to link it to her disability?
if it were as simple as you're not working because you have a disability, that would be an easy connection to make. It was more nuanced than that. It was knowing that when Ms. Smith was confronted, especially the way that Ms. Munger confronted her, that it could cause a panic attack. There had been a previous panic attack the year before, and Ms. Munger observed it. And she observed the what the symptomology were, the shortness of breath, not being able to breathe. And Ms. Munger mockingly asked if she should call 911. So it's more about tone of voice at certain times that connect it to the disability. Knowing that she had asked for a reassignment and she comes back in the very next day and you're sitting there waiting for her, knowing that that's going to trigger, that's the disability
Well,
discrimination.
I thought she said she was there waiting on her because she was late for work.
That's one of the reasons they have given. However, there's nothing. A week prior, and Ms. Smith did not have access to this, but a week prior, a performance review had been completed. There was no discussion of untimeliness. There was no discussion of work completion not being done. It was a glowing report. So how she went from being this lackadaisical, unresponsive, irresponsible employee on, April 24th to being, or on April 24th being this wonderful employee who's very conscientious, who does her job well, who's doing everything great, to then on the 29th, 5 days later, she has a history of showing up late. She doesn't want to work for a paycheck. She doesn't, she's lazy. She doesn't want to walk by my desk in the morning, so she takes the stairs, things of that nature. And all of those are connected to her disability in the sense that she has claustrophobia, so the stairs were necessary so she didn't have to take the elevator. So there are those connections that make it the disability-related claim. Now, I think that
I understand you're saying is relate, but I guess what I'm asking is how are you, show me allegations where you're saying that it's based on her disability. Not but how is the discrimination based on her disability?
everything that they did on the 29th forward was based on the fact that they viewed her as someone who was mentally ill and unstable. They restricted her access into the building. She had to be escorted into the building if she came into the building to work on her EEO claims. At one point it was asked if the staff would be given training on active shooter because Amanda still had an EEO claim, an existing EEO claim, and who knows what could happen. So there are things that are directly related to her mental health and their concern about her mental health and disability that are connected.
Was there a standard practice for people that were on leave in terms of having access to the building?
There was not. There are instances where other people had their computers with them, or if were allowed to telework, not necessarily if they were on sick leave, but were able to telework. In fact, Ms. Smith herself, would take her computer home with her and do work on the evenings and on weekends, as everyone else did. And I see I'm extremely over time, and I apologize for that. If there's any other questions, I will include the 28J and submit on the brief.
All right. Thank you,
Thank you.
counsel, both counsel, and we'll come down, read counsel, and then go to our last case for the day.
Your Honors, I'm Brian Wolfman. I'm the director of the Georgetown Law Appellate Court's Immersion Clinic. With the court's permission, Shreya Serene, a 3L law student in our clinic, will present argument on Mr. Hammock's behalf.
Thank you. Ms. Serena, welcome to the Fourth Circuit. Good to have you here.
Thank you, Your Honor.
You're not missing finals, are you?
No, I didn't have finals this semester.
This might be your biggest final.
It feels like it.
Go ahead, counsel.
Good morning, Your Honors, and may it please the court. My name is Shreya Serene, counsel for Appellant Terrence Hammock. I will begin by addressing Mr. Hammock's conditions of confinement claims under the 8th and 14th Amendments before proceeding on to his First Amendment claim.
Can you start with the jurisdiction issue that we?
Yes.
Yes, because I'm concerned regarding the jurisdiction issue. I know you all filed supplemental briefing, but it appears that what he's initially appealed was the April date, the decision from the district court's decision from April 1st, but then the formal briefing is discussing the decision, unless I got it mixed up, from March.
Yes, Your Honor. So Mr. Hammock filed his appeal from the final judgment of the district court. That judgment, the April 1st order, dismissed the last remaining defendant in this case, Dr. Barnes, and under the 2021 amendment to the FRAP 3C1B rule, that is all he needed to put in his notice of appeal. Every preliminary ruling before that merged into that final judgment, and so that is why this court has jurisdiction.
But he's, in that one, he's specifically stating that he is appealing his medical indifference claims. He doesn't discuss anything regarding his free exercise claims or his conditions of confinement, which would have come from the March order, district court order.
So under the amendment, Your Honor, he only needed to state the final order that he was appealing from, and because that order asked the clerk to close the case, that was the final judgment expressly designated as such, and so the March order regarding the conditions of confinement claim and the First Amendment claim merged into that and included that, and he attached the opinion of the court into that final notice of appeal that he put through. If there's no further questions on jurisdiction, I will address his conditions of confinement claims. Mr. Hammock was at the Baltimore County Jail for 2.5 years. During this time, he was served rotten fruit and meat with mice bites. Mr. Hammock complained to defendants that this food made him sick, that he could not eat this food, but the defendants did nothing to address his concern. In fact, they told him to eat what he was given, and that if he didn't eat this, he wouldn't get a different tray. Mr. Hammock also wrote a letter to the warden of the jail, defendant Gail Watts. He told her these exact same things, that the apples were always rotten on the inside and the outside, the meat had mice bites, that eating this food made him sick several times, that he could not eat this food, and that he had complained, but nothing was being done about it. He had to stop eating this food because it made him sick several times. He started losing weight. To get by, he had to rely on funds from his family to purchase food from the commissary. Because Mr. Hammock has pled a serious injury and has pled that the defendants were deliberately indifferent to this injury, we ask that this court reverse.
Sorry, tell me what the serious injury is.
A serious injury, Your Honor, is the fact that he got sick several times from eating rodent-infested food that he was served for 2.5 years when he was at this jail.
You know, that sounds terrible, right? It's no way to run a food service. But our precedents have a pretty high standard for injury, and they specifically address these sorts of food-related claims, right? And there's both a frequency element to it and a severity element. So there's the, frequency of allegations of how long it goes on and then how severe the injury is. And it looked to me like the case law is that just saying I got sick is not enough, is not severe enough. But he could also show a risk, right, of substantial injury. But that seems like it would go back to the risk of getting sick several times. Do you think saying I got sick is a severe injury under our precedent?
I think, Your Honor, if he had simply said I got sick, that might not have been enough, but he said he got sick several times, and he has also said that when he when he sent the internal grievance to Defendant Watts, that it is still going on. So the fact that he got sick several times and the fact that he kept getting this food for 2.5 years and that he couldn't eat it because he feared that if he ate it, he would get sick again, suffices to show a serious injury that he suffered at this jail. Because defendants knew
So
about...
that's like the frequency does a lot of work because the severity doesn't do much work.
So, Your Honor, because we construe Mr. Hammock's complaint liberally, he's a pro se plaintiff, and the fact that he has said he got sick several times, that his meat had mice bites, and that the bread was moldy, the apples were always rotten, the fact that he got sick several times, and the fact that he was afraid to eat that food again, drawing that inference from his pleading in his favor, he has alleged sufficient facts to show that the injury was serious. And because the defendants were aware of it and they did nothing to address his concerns, we know that Defendant Watts received those internal grievances. They were marked as such. He also received a response on which she was CC'd saying that his internal grievances were being processed as a Form 200, which is the last step of the administrative grievance process at this jail, that he would receive a response once the investigation in his claims had been terminated. He received no response. And so because the defendants knew about his injuries and his problems and did nothing to address his concerns, this court should reverse and remand on Mr. Hammock's 8th and 14th Amendment claims, and also find that defendants are not entitled to qualified immunity because under this court's precedent in Schrader v. White, it is clearly established that inmates are entitled to safe and sanitary food, nutritionally adequate food that is prepared and served under conditions that don't pose a risk to an inmate's health and well-being. Here, food that has been chewed on by mice and apples that are always rotten and bread that is moldy, that has already gotten him sick several times, does not meet nutritionally adequate standard. If there's no further questions from this court on Mr. Hammock's 8th Amendment claim, I will proceed to his First Amendment claim. Mr. Hammock has also pled that he holds a sincere religious belief. He's a practicing Muslim, and that the prison's policy has substantially burdened his ability to practice his religion by attending Juma classes or Juma worship services that are mandated by his religion. Juma services are group prayers that Muslim men are required to attend every Friday at around noon, and it is a time for sermon and worship for Muslim men. At that point, the jail should have put forward a legitimate penological interest justifying infringing on Mr. Hammock's right to be able to practice his religion. That they have not done. They offered a reason in the district court, that of COVID-19. But we know that Mr. Hammock was at this jail for at least 6 months before the pandemic started. The defendants have not put forward a reason justifying why Mr. Hammock was not allowed to attend Juma services for those 6 months. The district court relied on another reason based on Mr. Hammock's complaint that Mr. Hammock was in protective custody. But from the face of Mr. Hammock's complaint, we know only for sure that he was in protective custody in March 2022. Because it is the prison's burden to put forward a legitimate penological interest for the entirety of the period that Mr. Hammock complains about in the first instance in the district court, and they have not met this burden, this court should not undertake a Turner analysis at this stage and reverse and remand on Mr. Hammock's First Amendment claim. Because it is also clearly established that inmates are entitled to freely practice their religion absent a legitimate penological interest, which the defendants have not put forth. It would be premature for this court to undertake a Turner factor analysis at this stage. That is why we ask that you Your Honor reverse and remand on Mr. Hammock's First Amendment claims as well.
All right,
Thank you.
counsel, you reserve some time if
For
necessary.
yes, Your Honor.
May it please the court, I'm trying to lean over here.
I think you can straighten it up now, may help you.
There we go.
There you go. Go ahead.
May it please the court, Joseph Allen on behalf of Baltimore County. To start, as appellant did with the conditions of confinement claim, the allegations and the complaints made by Mr. Hammock in his complaint are clearly insufficient to meet the standard for an extreme deprivation of.
What standard of review did the district court use here? It seems as if maybe district court was going back and forth between, on a discovery, on a summary judgment versus a motion to dismiss. I was just a little confused as to what standard was used.
In the conditions of confinement, I don't believe the judge went outside the four corners of the complaint and treated it as a motion to dismiss. He just found that the allegations themselves were insufficient and didn't consider anything else that would convert it into a motion for summary judgment. So on their face, Mr. Hammock alleges in his original complaint that one time he got ill from eating rotten apples and or a mouse-bitten sandwich. But his primary complaint, which we can all agree is not a constitutional violation, is that he was served cold food when he expected to be served hot food. You see it throughout his complaint and his supplements that is his primary concern, and also the main reason why he stopped eating the provided meals for either 28 or the full 29 months out of the time he was in custody at the detention center. That's in his complaint. He says, I stopped eating the meals and I eat from the commissary, and I started losing weight because of that. So he doesn't allege that his loss of weight was directly related to him eating contaminated food. He chose to stop eating the provided food, and the commissary substituted for that. I would also note that
He solely stopped because it was cold? Are you saying that?
no, Your Honor, I said
I
that's
heard
the
you say that one time he saw this and then he stopped eating because of that. Is that what you said?
No,
I
one
didn't-
time he got ill.
One time he got ill. He said, in his complaint, he said he only got sick once.
Correct.
Just one time. Okay.
Well, let me explain. The appellant said that he claimed he got sick several times in the past. That comes from the Joint Appendix 26, which is a letter, one of several, attached to his supplemental complaint, which the court treated as just an addition to his original complaint.
Mm-hmm.
In his supplemental complaint itself, he only said that the meals were cold, okay? And in one of the letters that he attached to the supplemental complaint, which was ECF 7 below, that is the only place where he says, and I quote, "I got sick several times in the past." But
That's part of the record, isn't it?
yes,
Yes, yes.
Yes, Your Honor.
And this is summary judgment, right? Granted, was it summary judgment?
no, Your Honor, the court didn't reference the several times. in his memorandum of opinion. He said one time. So it's not clear whether the district court took into account.
So we don't know what the district court did.
Well, even if the court had considered Mr. Hammock's complaint that I got sick several times in the past, that's still clearly inadequate to meet the standard of an extreme deprivation. And that results in a serious illness or injury.
Extreme deprivation, well, you know, I don't know, it seems to be rather off-putting to go to bite your sandwich or eat your food and you see the mice or whomever, whatever, have beat you to the meal.
That's true.
I mean, I don't know about you, but I mean, I think I would lose my appetite. What do you think?
I don't think that's arguable, Your Honor. I would prefer not to.
Prefer not to? You would not?
Oh, that's not the question.
It's not the question. That's to the point where, you know, commissary is hard, you know, when you're locked up and you're away from, you know, you put away and trying to get somebody to get you to commissary. He said to the extreme that he had to do that in order to survive. That's what he's losing weight. And he does talk about cold food, which I would too. I mean, I don't know how you call it. Every meal was cold, and that's okay, but maybe that's not severe, but I suppose you can eat it, but isn't that pretty severe, just the frequency of it? I mean, you get these meals, and you know, it's just afraid. It's like you go to some place. I mean, just think about it. If the rat is there, if the mice are there, they're also not only eating, but they're eliminating too. So the rat mice droppings are all around. You thinking you eating that's pretty dehumanizing, isn't it? Don't you think?
I can't speak to dehumanizing, Your Honor, but
Wow. Go ahead.
Your Honor, if there were mouse droppings in his food on a daily basis, that would be dehumanizing. I agree with that. But that's
And that
not
would be a
what-
constitutional violation, right? There are cases saying that, right? If there's mouse droppings in your food more than a couple times, it's a constitutional violation, but courts draw the line at a couple times versus more than a couple times. We have
Right.
cases about that, right?
Yes, Your Honor, and there's a case where an entire fried rodent was found in a meal, and that was not deemed to be the.
I hope that wasn't the Fourth Circuit. What was that case?
There aren't any.
Was it a Fourth Circuit case?
I believe it was a district court case. I think it was from Maryland. It may have
District
been-
Court?
Yes, ma'am. Well, there aren't any Fourth Circuit reported decisions that say what is the.
Exactly, right. So now, for us to look at it, see what is dehumanizing in terms of when you get food that you see that a rat or a mouse has already started the meal and eaten it, and then you're served that. Somebody says, give you a tray, and the man says, here, this is your meal for the day. And then you see that a mouse or rat is eating from that. In other words, they carry rabies, don't they? As a matter of fact, I think the rabies are in their saliva.
I don't know about that.
Well, yeah, that's what you got to know a little bit about science. I mean, we come to these cases, you talk about whether or not something is dehumanizing, what the threat is. You got to know what the severity is. Or to know something about rabies, don't you? I think it's through the saliva. Saliva gets in terms of, you know, that kind of. But anyway, never mind. But go ahead. Argue your case.
A detainee or an inmate still has to allege that they actually suffered a serious illness or serious injury from eating the contaminated or otherwise inadequate food. Mr. Hammock didn't do that here. He claimed that he got ill one time, and even assuming that I got sick several times is included in his complaint. That's not enough. And the appellant relies.
Is it the case that for this entire period, the objective severity standard is the same, right? The the intent standard, the mental state is different when he was a pretrial detainee. That's an objective standard. And after he was convicted, that's subjective. But my understanding from our short decision is that that's the only thing that changes between being a pretrial detainee and a convicted prisoner, and that the objective severity standard is the same across the entire period to rise to the level of a violation, whether we're talking 14th Amendment or 8th Amendment, directly as a punishment. The standard for serious or significant physical or emotional injury or a substantial risk of that injury is the same across the period. Is that right?
Right, Short didn't change that, and it's not pertinent to this case because the judge never reached the deliberate indifference as to each individual defendant, officer or official, because the pleadings were found to be inadequate on the constitutional violation itself. So whether each Director Watts or other individuals were deliberately indifferent to that.
Right, that analysis wasn't done because it said as a matter of pleadings, it was not sufficient.
Right.
It's almost as if it was a, what is it, 12B6? Really, almost. Wasn't it, in that sense?
Yes, Your Honor.
Yeah, it was, right?
He treated it as a motion to dismiss, even though he
Yeah.
talked about in the opinion that he could convert it to a motion for summary judgment.
Room 50, yeah.
Although he denied the request for, the discovery by Mr. Hammond.
Yeah, denied.
But he didn't go outside the pleadings.
He did not go outside the pleadings.
Right.
On the free exercise claim?
On the free exercise claim, it's the same, except for he considered the county's argument on COVID-19, which is not in the pleading.
Well, that's what it seems like on the confinement claims that there is 12B6, and then it seems like on the free exercise that we're at summary judgment. So that's why I asked that question earlier about where are we in terms of standard of review?
I believe both are on the motion to dismiss stance. The main thing that the judge considered in the free exercise context was the attachment to Mr. Hammock's supplemental complaint that was the denial slip for his request to go to group Islamic services. So the judge took into account the argument that the claim that Mr. Hammock made in his supplemental complaint, that was, this is the reason why I was denied the ability to go to group religious services.
Why was he denied before COVID?
Well, it's not in the record, Your Honor, but there was.
So if it's not in the record, could the district court grant summary judgment or a motion to dismiss against the plaintiff?
Yes, and this is why. Even though the court did find that there were legitimate penological interests in the COVID-19 and in him being in protective custody for at least a part of the time, the Firewalker Fields case is right on point here. And I would propose.
No, it's not. I know that. I know Firewalker very well.
So
Yeah, in that record, they had they provided prayer rugs, and it was scheduled. I mean, there were a lot of things that went in terms of accommodating his religious practice and his worship. Here, you don't have anything else except that COVID maybe, or maybe I'm protecting him and from being a protected person. That's different. Firewall is totally different than this. You don't have those kind of facts here, in that case.
I would disagree, Your Honor,
No,
because
I'm sure you do. Go ahead.
Mr. Hammock did not allege that his individual freedom to exercise his religion or his religious practices was infringed at all. And in that circumstance, like the language in other words, he didn't allege that he wasn't provided a prayer mat or that he wasn't allowed to pray. He only alleged that he was not allowed to go to group Islamic services. And I would...
So on that record, then, that's what he required for his religious practice. Firewalking in the sense that those things were accommodating a part of what he wanted, correct? There's no evidence here at this point, at least at this juncture, that he wanted anything other than the group prayer at noon on Fridays that's required.
That's what he wanted, and that's what the plaintiff inmates in Firewalker wanted also. And so they were provided with the means and ability to practice their religion individually, and Mr. Hammock didn't allege that he wasn't.
But like, we can't evaluate, like Firework Fields gets into evaluating whether what the prison's reason for not letting him do one thing and whether they accommodated his religious concerns in a different way. But here we have no reason. There's no reason. We can't evaluate a non-existent justification for the prison policy or decision that we're presented with. Can we? I mean, isn't that what's missing here?
For the brief period of time when he was supposedly not in protective custody or the COVID-19.
I mean, supposedly, yeah, you haven't said he was in protective custody. I read your brief with great interest to find out if you would take a position even outside the record, and you don't, which I guess you can't because there's no record on it. But we don't have anything to go on. We can't evaluate a policy that hasn't been presented to us or justifications that haven't been presented to us.
I would say that Firewalker Fields stands for the proposition that there is no constitutional right to group religious services. And I quote from that decision, "The relevant question is not whether the plaintiff had the opportunity to engage in Friday prayer on his terms, but whether he could generally engage in worship." Here, Mr. Hammock did not allege that he wasn't generally able to worship. It's not in his complaint.
Was that the grounds of the district court's decision?
Yes, Your Honor. Yes,
One of the grounds was that they gave him, I thought he said that he was in protective custody and COVID was sufficient to say that that's why he was being denied. He didn't go into that analysis in Firewalker and those things, or even inquire there, did he?
He did quote extensively from Firewalker.
Yeah, he did. Because he was quoting in terms of things that were used to assess the policy that was at issue, but that's not in this case at this point. I mean, you basically, I agree with Judge Rushing's point is I thought that would be what you put in. Look, here's why we didn't do this. Here's what he was allowed to do. Nothing. So I guess I presume the inference is that you allowed him, he did nothing. You allowed him to do anything. That would be because all the inferences are against you, right? So therefore, since you didn't put that forward, maybe you didn't allow him to do anything, nothing. Now you're trying to take advantage of, if I say nothing, now you got to assume everything Firewalker was, I did that for them. You can't do that. That's why I meant it's in opposite in terms of choosing Firewalker, just to dump that in your case and say, look, you see, when you do all of this, it's fine. But you don't have that before us. We don't know what it was. We're dealing with a person who was in his cell by himself, in his cell and not doing anything. As far as we know.
Well, he didn't complain about that, Your Honor. And that's what we have to start with, is the actual words of the complaint and everything else that was incorporated into it, like a supplemental complaint here. He had the opportunity and the motivation, if he wanted to complain about not having a prayer rug, for instance. He didn't do that. The only complaint he made, and which is why I'm not asking you to make any assumptions about his individual practice, is he didn't complain about it.
Okay, the logic, your logic is, in terms of formal logic, would be because he didn't complain about that aspect, then it means that he must have been getting it.
I mean, it's not before the court, is the is my point.
Yeah, but the point, but what he did is says that we couldn't go to the Friday services, right? He wasn't
Right.
allowed to, at noon, this was required in his religion.
But he's not
That's what he said.
he's not entitled constitutionally to any particular religious accommodation, right? That was in Firewalker, where they had no group-led, no inmate-led group meetings of any kind. They wouldn't let max security prisoners out to congregate.
But they did do this.
But they did have the.
But you don't have the, but they did do this. That's missing in this case. At this point.
Yes. Yeah.
But you want us to fill in the blank that you did all of those things, right?
No, I want you to.
Or you're saying that it's okay if all they did was, okay, we deny you for reason of COVID or because you're in protective custody and we do nothing else, that's fine. If that's the inference to be drawn, that would be okay. District court said, yeah, under fire, well, you don't have to do anything else. The fact that he asked for this, and therefore, if you did nothing else, that's fine.
I think a bare minimum explanation for the denial of group religious services would be sufficient under the Constitution. For example, the Firewalker Fields, they relied on outside volunteers for any of their group religious services to be run by them. And if there was no volunteer for the Islamic services, then that was sufficient. That was a sufficient explanation, is that we don't have, and there's no obligation on
What's your record though, here, on your side, your ledger? You come here with a tabula rasa and saying that we're gonna give you we gotta assume that you did the same thing that was available for him? Maybe it was, but you have to assume that because it's not in the record.
Right. Even with a pro se complaint, Your Honor, the plaintiff has to put forward what the claims are that he's complaining about. And here, the only thing he complained about was not being permitted to go to group Islamic services.
And it sounds like as I understand it now, today, your argument is, as a matter of law, it does not violate the First Amendment to deny a prisoner access to group religious services, period, no matter what else you give them, whether you give them something else or you don't. Is that your position? It's a legal question. You can deny a prisoner the right to go to religious services, full stop, so he's failed to state a claim.
In a circumstance where the detainee or inmate, or the inmates generally, are provided adequate opportunity to practice their religion individually.
So that's the part we have to know, right? So you're not making the legal argument that he didn't state a claim by just saying I was denied access to this group service. You're saying it depends on the justification and what else the prison offers and all these other things that we don't know because we don't know the justification and we don't know what else the prison offers.
Well, Your Honor, I would say that I am saying that there is no constitutional right to group religious services. Because if there was, in Firewalker Fields, that denial of services would have been found to be unconstitutional. It's in a circumstance where there is no allegation, right? This is coming from Firewalker Fields, that he was prevented from engaging in individual religious practices. The claim fails because the pertinent question is not whether the inmates have been denied specific religious accommodations.
Was that on a motion to dismiss in Firewalker Fields that he, because of his allegations, he didn't allege all the good things the prison gave him, and so it was thrown out?
I believe so, Your Honor.
Or was it based on evidence from the prison of what they said was their policy, why their policy was a certain way, what else they offered?
I don't know if those explanations came from the motion to dismiss in that case, or if there was a record developed outside of that.
But here we have just the COVID time and no explanation for before or after from the prison.
Yes, sir. But I have to come back to Fireworker Fields. Because he didn't allege that his individual religious freedom was infringed on at all.
Oh, he did allege that, he did allege that, maybe not, he did allege his religious belief and practice were infringed upon.
Not his individual freedom to practice. He's alleged, and that was the distinction that Firewalker Fields made. Like, if you got prayer mat, you can pray when you want to pray. You can even do Friday prayers at the appointed time. You just can't, or you're not.
It's like somebody saying that they wouldn't allow me to have Holy Communion. And then you say, well, it's not individual, but someone normally administers it to you, right? The Holy Eucharist. But you would say, well, you didn't say, you only said you're individual. But if you say, well, no, I'm not going to allow anybody to come in to administer it, would it?
Well, there's no constitutional right to have a priest come in and give Holy Communion.
Mm-hmm. Or it's not. You don't have to provide people who are Catholics who are incarcerated. You don't have to provide for them for other religions.
No,
at all. Okay.
The jail or prison doesn't have to go out and get someone from the community to come in.
If that's provided for other religions services.
Well, that came, yes, Your Honor, that came up in Firewalker Fields also. Because it was there.
Because Firewalker Fields was they were assessing what was done there. Here you want to take a record where you have put nothing in and get to an incredible opinion that says, no. Otherwise, it's full stop there. We don't have to say we're doing anything.
Unfortunately, Your Honor, the only argument made in the motion to dismiss was related to the COVID-19 pandemic. The judge expanded on that explanation by referring to Mr. Hammock's own pleading and the attachment thereto to decide on that issue.
Okay. And what did you put in the record that it was based on COVID? What did your side put that in?
In the motion.
Okay, just the motion to dismiss.
Yeah, or in the alternative for summary judgment.
Right. I mean, any evidence of it? I mean, what did you submit? Just the response from lawyers? That's it?
That's it, Your Honor. Nothing.
Right, as I thought. Yeah, argument. Okay. That's
well, the
your
motion.
time is well over, but if you have something to say in the next 30 seconds, you may go ahead.
No, thank you, Your Honor.
All right.
Thank you, Your Honors. I will begin by addressing the two claims that opposing counsel made, one about the Eighth Amendment claim and one about the free exercise claim. First, as to the risk of injury that Mr. Hammock suffered, the Supreme Court has recognized in Helling that an inmate does not have to wait for something tragic to happen, to the extent that if they know, for example, that they're drinking contaminated water, they don't have to wait for dysentery before they can make out a claim for injury. Here, Mr. Hammock got sick several times, and he saw mice bites on his food. A fair inference can be made that he was disgusted by that. He got sick from it, and he didn't want to eat it again, and he likely thought that if mice have access to this food, God knows what else they have access to in terms of what he was given to eat. As to the free exercise claim,
you're right that there doesn't have to be an existing injury. The Supreme Court's expanded it to say a substantial risk. But in assessing the substantial risk here, it's a risk of, seems like it's a risk of what happened in the past happening again, right? Which we know is I got sick. We don't know anything else about that. That there's a risk of that happening And then potentially, he said, I started to lose weight. There's potentially that as a risk in the future, but that seems to be the universe of risks we're talking about, isn't it?
Yes, Your Honor. And so for the injury element of the deliberate indifference claim, it has to be a serious injury or a substantial risk of serious injury. So those are both parts of Mr. Hammock's injury here. He actually did get sick several times, and he was exposed to this risk continuously when he was served this food for 2.5 years.
And it's your position that any version of getting sick rises to the constitutional level of a serious or significant physical injury?
Like Your Honor said before, it depends on how many times it happens and whether there's a credible risk of getting sick from the food or other conditions of confinement.
Does it depend on the severity of the sickness? We have some cases, that are cited in the briefs about that.
Yes, Your Honor. It depends on how many times it happens and the severity of the illness. So the burnt rodent case that opposing counsel talked about, the inmate received a burnt rodent in their meal one time. They didn't eat it, but that was it. That was the claim, and obviously that case was not appealed. But here he has mice bites. He's gotten sick, and he was exposed to this for the entirety of the period. The inference is that rodents had access to his food, and that creates a risk of foodborne illnesses. And so he has sufficiently pled that he suffered a serious...
So you disagree with the cases that say a few times instances of mice droppings and mice evidence in food 1 or 2 times doesn't rise to a constitutional violation? You would disagree with that because if there's any evidence of mice, that would give a suggestion that they have access to everything and they've been there for a long time. So we would have to disagree with all of the circuit courts that have said a couple of instances of that is not a constitutional violation.
So in those cases, either the jail did something to address the problem of, for example, maggots in food. The jail did something to address the problem, whereas here, after complaining for 2.5 years about this repeatedly, nothing was done to address his concerns. And so those cases are...
Sorry, I don't want to hold you up on that articulation. Did he complain for 2.5 years? I saw complaints shortly before and after he filed his complaint in this case. Did he complain at the very beginning in 2019?
So in his complaint, he talks about how he has complained multiple times or several times to defendants, and they've done nothing about it. While we don't know exactly how many times he complained, I think we can draw an inference that it was definitely sufficient times to defendants and to the warden specifically, enough times for them to they should have taken notice.
There seemed to be multiple complaints clustered around a certain time period in 2023, right? I think that's the year, 2022, 2023?
So it's 2019 to 2022, and in the complaint, he talks about how he has been complaining since he got there and nothing has been done about it. And in the letters to Defendant Watts, he also says those things, that I have been complaining, I don't know if you got my Form 118.
Because he talks about, I've been complaining, I took my cold tray back to the cafeteria line and asked them to warm it up and they wouldn't do it. So he's definitely complained to those individuals was the allegation.
Yes, Your Honor, and he's definitely told them that he can't eat this food. And so an inference can be drawn that the fact that there were mice bites on his food, the apples were always rotten, the bread was moldy, and the fact that he was exposed to this for 2.5 years, he has made a claim for injury. As to the First Amendment claim, I will first address that Firewalker Fields was on a motion for summary judgment, and so there was a record there. The prison had offered a legitimate penological interest, to which the court applied the Turner factors to assess whether the offered legitimate interest was reasonable. Where one has not been offered for the entirety of the period complained of, as is the case here, it is premature for the court to engage in the Turner analysis because we don't know as to COVID, we don't know what the prison's policies were during COVID. Were they offering any congregate worship services? Were other religions being accommodated? When did the restrictions start to loosen? We know in the real world, those restrictions were evolving. Was that happening in the prison? We don't know anything about that. As to the protective custody claim, from Mr. Hammock's pleadings, one can infer that he was allowed to go to the law library a few times from September 2019 to December 2019, and so to the extent protective custody at this prison means that an inmate cannot interact with other inmates, the fact that he was allowed to go to the law library where his complaint says there were other inmates there undercuts the reasoning that even if he was, even assuming he was in protective custody, that couldn't have been the reason, that wasn't even put forth in the first place, and maybe that's why it wasn't put forth in the first place. Finally, Your Honor, I would also like to say the jail put the religious services memo in Mr. Hammock's protective custody unit. So to the extent protective custody means that inmates can attend religious services or go to religious services, we don't know why that memo was in a protective custody unit at all. If there are no questions from this court, I would ask that this court reverse and remand on Mr. Hammock's claim, and also ask that the district court reconsider appointing counsel for Mr. Hammock to assist him with discovery.
Thank you, counsel.
Thank you, Your Honor.
I just want to note, Mr. Wolfman, thank you so much. The Hoyers were well acquitted today, you heard from. And would you please give your name for the record? I know you must have had something here to do to help with this here.
Elizabeth Brownstein.
And your student as well?
Yes, sir.
Well, good. Good to have you both. Thank you, Professor. Appreciate it. Of course, appreciate the efforts of also Mr. Allen as well. All right. We'll come down and after you adjourn the court, we'll adjourn the court until tomorrow morning.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.